All right, Ms. Hilton, based on our discussion and understanding your objection, do you have any edits or proposals to the highlighted language?
None for the sake, Your Honor.
All right, Mr. Korn.
It seems a bit convoluted, but I'm not sure how you can make it less complicated. I'm thinking about it. Maybe bullets as opposed to one long paragraph.
Your long sentence, Mr. Judge.
Because they have lists in them.
Yeah.
I agree.
Can you make a paragraph out of it, so maybe at the second end with the, it's not a real paragraph, but. So maybe at the if, you can, make that a new.
Quite sure why they're red. All right, let's talk about accident. Take the highlight off all this stuff. All right, accident is on the screen now. So I'm happy to add criminal negligence as in a definition of, I think for purposes of this trial and my understanding of Booth and Springer, criminal negligence equals reckless conduct. And so it is in the charge right here, the thing that I just made gray. Maybe what I ought to say up here for accident is no person shall be found guilty of any crime committed by accident in which there was neither criminal intention nor reckless conduct. So we're using the phrase that will come up later because that's our stepping stone. There's lawful act in an unlawful manner, whatever that means in this case. Then there is criminal negligence equals reckless conduct. And so let's just call it reckless conduct.
I agree, Your Honor.
Okay. Mr. Korn?
I agree also.
Okay. I think that'll simplify it for the jury. And I think fits this case. Where did accident go? Come back. Okay. So really, you have the longest menu I've seen in a case, Mr. Korn. You can say it was accident, not guilty. Hey, he did his best, but it ended up being in an unlawful manner. So this involuntary that precludes everything else. Then it was just involuntary because it was reckless. And then I don't know why you'd argue it, but you could say, nah, it was neglect of an elder, which would get you felony murder. But it's, I mean, it's four levels, these poor jurors. Okay, Ms. Hilton, did you have anything else?
Nothing about the charges, Your Honor, just if you give it.
Okay. I'll do that before the jury comes out because I think I can clean up the one I did. Ms. Jenks, does the defense have anything with the jury charge?
With that copy of the jury charges before we start this?
Yes, if I print it out, that's the final version, absent, I realized something during your closings that I need to change. So I need to know if there were any, I thought Mr. Korn said there was something else he wanted to talk about in the jury charge. Okay.
On the charge of, okay, after carefully reading the Booth decision, first of all, I did note one small distinction and procedure in Booth, that all the charges, the felony murder, the elder neglect, the involuntary manslaughter, the reckless conduct, were all indicted.
It was an interesting indictment.
Yeah,
Yeah.
I was actually a bit surprised by that. I've not seen one quite like that. But this case is not that situation, it's lesser, and I don't know exactly how that influences the mutually exclusive portion of all this, but I just thought that was something I felt like I needed to point out. Secondly, on the duty of care charge, nowhere in the Booth decision is there language that the state does not need to prove that the defendant had a legal duty to provide care to his mother, etc. What the Booth decision does in a footnote is essentially recite the statute, which does impose a legal duty on somebody who cares for, it says a guardian or other person supervising the welfare or having immediate charge, control, or custody of a disabled adult, elder person, etc. That is a legal duty. That is imposing a legal duty on the person who has the immediate charge. I don't think it's correct in the statement of law to say that the state doesn't have to prove a legal duty. They in fact do have to prove a legal duty, just not one that's imposed by some court anywhere else, just the one imposed by the statute, which is actually already in the charges directly above, starting on page 11, going on to page 12.
Okay.
I would object to the duty of care, and that is one, an incorrect statement of the law that there is no legal, state does not have to prove a legal duty. And two, it is superfluous of the statute itself.
You did much better that time.
Got it this time.
You did. Okay. I hear you. I'm going to follow Bone and the language from Bone. I appreciate that Bone dealt with, as Ms. Hilton pointed out, a predecessor statute to 165101A, which is the neglect of an elder. What I believe an element that the state has to prove is that Mr. Rooks was in fact supervising the welfare or had custody of the elder person. That's an element. What they don't need to prove is that there was a legal obligation, that someone had determined that Mr. Rooks was the legal guardian. They don't have to produce a document where a judge said, you've got this obligation to do that. I don't think it's what the statute says. And I think the proposition that I am importing from Bone is that one, that there isn't a legal duty. There is a fact that the state must prove beyond a reasonable doubt, and that is that Mr. Rooks was supervising the welfare of his mother. And I think that would be a relevant debate, for example, if Cameron Rooks were being prosecuted, because it sure doesn't sound like the evidence would support a finding beyond a reasonable doubt that Cameron Rooks was supervising the welfare of his grandmother. So I note your objection, you've preserved it, and we may make more law because the Court of Appeals or Supreme Court, if there is a guilty verdict, depending on where that guilty verdict finds, may say Bone was interesting, Bone applies to cruelty, it doesn't apply to neglect of an elder. It's the only case I could find that sheds some light on it, and I think it is sufficiently analogous that I am importing that legal proposition to this case. But you have made the case for why I ought not to do so and preserved it should that be something that needs to be appealed. Ms. Hilton, anything you want to add in connection with duty of care? I do want to get in the record a few of the citations I relied on in the discussion about involuntary manslaughter. Booth is at 311, Georgia 374. It relies heavily on Springer, which is 294, Georgia 376. And of course, MacGyver is so new, it only has a 2022 Westlaw 235-2093 citation. It's case number S22A0093. And I don't have Bone in front of me. Does anyone have the Bone site?
Yes, sir.
Oh, yeah, I may be able to find it there.
Honor, it is Bone v. States, 283, Georgia Act, 323, the 2006 case.
Yep, great, thank you. Did you have other concerns about the jury charge, Mr. Korn?
No, no.
All right, let me clean up the verdict form and get you all hard copies of what for now is the final charge.
Yeah. Yeah.
All right, I'm gonna go print that out and do the verdict form. You guys have a couple more minutes. You should get your PowerPoint on warm standby.
Okay. Okay. No. I had it bigger.
All right, Gordon, if you would, one verdict form for each side. Whoop, they don't get that. And 2 sets of jury instructions for each side. Ooh, easy. Oh, I need something's the original I get. I thought I grabbed that. The one with blue, don't give to anyone. Thanks. Exactly. All right, Ms. Hilton, if you and your team would look at the verdict form, and Mr. Korn, if you and your team would look at the verdict form, I think it reflects what we talked about. It is more convoluted than your usual form, but so is this case. All right, Ms. Hilton, any questions or concerns about the verdict form?
Yes, Your Honor. Another case, well, the case, the point, however, I feel like my experience is not guilty should be first, then guilty, on many of my verdict forms. So that will only be the state's one part. And then I know with felony involuntary manslaughter is not mutually exclusive, so I don't know if it has the same considerations as voluntary manslaughter, having to put voluntary manslaughter before the murder counts, but in an abundance of caution, I would say that we put the involuntary manslaughter reckless conduct above the murder charges.
Okay. Mr. Korn, any concerns with the verdict forms?
Beyond those, no.
Okay, I'm aware of no case law that says you have to put not guilty before guilty. And normally I would do exactly what you said about the involuntary, but we're now in this rare air of Booth and Springer. And so I think the one charge that has to be considered first is misdemeanor involuntary, which we're calling lawful act involuntary. And their instructions as to what to do with that. But otherwise, I don't think that the jury needs to consider reckless conduct involuntary first, second, third, fifth. They are part of the species of, well, what level of mental culpability are they going to find? Because one doesn't knock the other out, I'm comfortable with how this looks. It's a complicated verdict form, but I think it will guide the jury. I just hope they can navigate it, but they know how to ask questions. All right. Anything before we bring the jury in? They've been waiting patiently now for 40 minutes.
So stay straight, could you email us the verdict?
Okay.
But it's not, but.
No, it's not a problem. This is not a secret document. Mr. Korn, anything before the jury comes in? All right, let's bring him in, please.
Thank you.
You're welcome.
All right, the jury.
Thank you, Deputy Gordon. You all can be seated. Good morning. Thank you for your patience. We were here, not before all of you. I let some people in pretty early today, but we got started well before 9, working through this, which is the charge I'll give you after closing arguments. And there were some more complicated legal discussions than I had factored into our schedule. And so we used some of your time while we worked through that. So I apologize. Maybe more important, I think yesterday was someone's birthday. Which juror's birthday were we celebrating yesterday? Tuesday. It's been together for so long. Who had a birthday? Happy birthday. All right. 2 days ago, it's your birthday. Well, what a great way to spend your birthday. Yeah. That'll go in the annals of wonderful birthdays. Hopefully you remember, late last night, we heard both sides say rest, no rebuttal, et cetera. The evidence is closed. All that remains are the closing arguments or summations from both sides. The state is entitled to go first and last, as I mentioned. The defense doesn't have to do anything, no burden, but I bet we'll hear a closing argument from one or both of the defense attorneys. Reminder, nothing the lawyers say in their closings is evidence. They are trying to persuade you as to what the evidence has been and what that means in the context of the law I'm going to give you. It proves this element. It fails to prove this element. That's all legitimate for them to argue with you, to you, what's been proven or not proven. But you will decide what the evidence is. A lawyer telling you the witnesses said it was raining that day. That's not what you remember. You remember the witness say it wasn't raining. Hey, remember the lawyer said what the lawyer said is not evidence. But they are here to explain what's gone on and how that fits in the context of the law that I will give you at the end of their closings. Ms. Hilton? Well, all right. Hopefully you had let the defense know that. Not so much. Okay. Do you need a moment to get oriented since maybe you thought you had a little while?
I do not.
Excellent, Ms. Jenks. Thanks for the nimbleness.
Good morning, ladies and gentlemen. I'm not sure if you remember yesterday that I objected to the state using the word murder in her cross-examination of Mr. Rooks. The judge overruled my objection and allowed it. But remember, Mr. Rooks is presumed innocent. He is innocent from the beginning of the trial all the way through the end, cloaked in the presumption of innocence. And he remains cloaked in that presumption of innocence all the way through the end of the trial. When we start looking at the evidence, evaluating it, deliberate, and decide on the verdict. I want to also thank you, all of you. Actually, that doesn't work. I want to thank all of you for your service on behalf of co-counsel Mr. Korn and Mr. Rooks. This has been a long trial, and it's been a tough trial. It's a tough trial to sit through. But you have been attentive throughout the entire trial, ladies and gentlemen, and we really appreciate that, because this is Mr. Rooks' life. Honor your mother. Phyllis Rooks truly believed that he was doing just that. His mother's wish was to die in her own home, the home she had lived in for 50 years, where she raised her children, watched her grandson grow up, saw her youngest son die, and saw her husband deal with his illness. She was adamant. We heard it from Mr. Rooks yesterday on the stand. He used the word adamant. Mama wasn't going to see any doctor other than Dalla. Mama wasn't having anyone in her house. She refused to go to a nursing home every time he brought it up, to the point of tears. I have a house. This is where I went down. She walked out of the hospital. She pulled things off of her and walked out. She would not be forced to go into an assisted living facility. She was going to die alone. Now, Mendoza Rooks was a wonderful woman. And she was a great mom. We heard from Mr. Rooks that she went fishing, watched his football games during high school. She even had Falcon tickets, season tickets for the Falcons game. She taught her kids. She took him from school to school when she moved around to see what was in his best interest. And they had a good relationship. We heard that from Mr. Rooks and through Jay, his longtime friend. And she loved dogs. She was always into dogs. Now the state showed us some photos of her in her younger years. She was beautiful, she was active, she was vibrant. And that's when she had her wits about her. However, in 2006, when her youngest son died, part of Mendoza died too. And in 2012, when Jimmy died, her husband, an even larger part of her was affected. Their deaths were a blow to our family, is what Mr. Rooks said yesterday. It was difficult. They were mourning. It was like one after the other. Mendoza was never the same from that point on. In 2012, much of Mendoza's spirit and psyche changed. We heard that repeatedly from the witness stand. She was depressed when Jimmy died. She couldn't remember things. Her behaviors changed. Catherine Alston, the neighbor, said she hadn't seen Mendoza very much outside the house after he died. She testified to that. Her grandson, Cameron, sat and said, yeah, I knew grandma. I lived there during high school years and I tried to take her grocery shopping after Jimmy died, after Grandpa died. But I couldn't do it anymore. I did it once or twice because something wasn't right. She wasn't behaving like herself, the grandmother that he knew and loved. She was forgetting things. She was forgetting her keys. She was forgetting her purse. And she had confused and chaotic behaviors. He used the words chaotic on the stand when he testified. She'd forget things. And he couldn't take her out anymore. And he wasn't nervous to take her out anymore. It was tough and perhaps unsafe. Now, where's Hilius at this point in 2012? He is living his life, a very regular life, not a lavish life. He's working every day at Georgia Tech as a maintenance guy, that morning shift from 8:30 to 5:30, somewhere in there, getting up every day at 5, getting ready for work and going to work every day. He was just getting by from his jobs and his side gigs, working, checking on Mom regularly, making sure there was food in the refrigerator. But don't forget, Hilius was also mourning these deaths. He was close with Addison. He was close with his father. He was also going through his grieving process at this time. Now, he wasn't living at home between those years of 2012 and 2017, but he had a good relationship. He was living with Jay in that Buckhead apartment she talked about, sharing the expenses and being roommates. And he had a couple of those side gigs, the music studio and the home improvement jobs. And he always worked close to Mom's house. We heard that several times from this witness stand. He wasn't working far from Mom so that he could check on her, bring her food, make sure she was okay. Now, unfortunately, who we couldn't hear from, ladies and gentlemen, in this case, that would have been helpful is Ann Occidel. Occidel passed in 2020 at the start of COVID. But remember, there was testimony about her involvement in taking care of Madoka, her sister. They were close. They had a good relationship. She was there 3 times a week, taking her to some doctor's appointments, sitting with her, eating with her, watching Madoka do the lottery. And that happened until 2 months before she died. Once Occidel stopped helping Madoka, Hilius moved in with his mom. He didn't have to move in. He had no legal duty to do so. He moved in specifically to take care of his mom while he's still working full time, trying to make extra money. Mr. Rooks is not a doctor. He's not a nurse. And he had limited skills in terms of caretaking. He kept fresh food in the refrigerator like he promised his father he would when his father died. He bought his mom her favorite soul food. It may not have been the diet that a nutritionist would have given her based on her list of ailments, but it was her favorite food. She liked it. And he wanted to make sure that she was eating the things she liked, especially at this time. He made her meals in the microwave. He turned the gas off so that the stove, wouldn't be on and there would be no danger from that. And he did the best that he could do. The best that he could do. Now, 2 weeks prior to Madoka's death, we heard from Mr. Rooks, from Hilius. She said, I'm gonna get up out of here. I'm gonna get up out of here. But this may not sound like much to us. However, to Hilius, it was meaningful. His mom was ready to pass. He had heard something similar from his brother before he died, and from his father before he died. He was overwhelmed, emotionally, psychologically, and remember, this trajectory of dementia didn't just happen in the 2 weeks prior to death, didn't just happen 2 months prior. It started in 2012. And I think there may have been even testimony, rely on your own recollection, that it happened before 2012 in terms of her forgetting things. It was a long journey of dementia. And he was emotionally and psychologically overwhelmed. He didn't call 911 in those last 2 weeks because he knew that his mother did not want any medical intervention. He knew. She told him. She didn't want to go to any doctor. Dowda had died 2 years before. She didn't want to go to a hospital. She was trying to get out of there the couple times that she went. She wanted to die at home. Now, the weekend before Madoka died was not. There is no denying that. Ilias may have thought that it would go better than it did. But when he came on Friday, he did what he usually did, and that was it brought home takeout on Friday night to give to his mom. Soul food meal that she liked at $20 a pop, he said. She ate and we went to bed. Saturday morning, he made her breakfast. Now, this was a more involved breakfast than during the week. He explained to us that during the week, she got soup because it was easy and quicker when he had to wake up at 5 o'clock in the morning to get ready for work, get her taken care of, and go to Georgia's house. But on Saturdays, on the weekends, he made a more involved meal. In the microwave, he would feed her differently on the weekends, a different meal. And that was part of the way that Hilius marked time from those habits. And he talked about when he saw the video of Liam Packer interrogating him, he was like, those are not the dates. Those are not the dates. Even though the state is trying to say, well, that's closer in time. I don't understand that. Wasn't that back in February 2017? But in February 2017, he's a mess. He is overwhelmed. And so he remembered that actually those dates are not right. And he realized that based on what he usually does, his habits of what he fed his mom, it was incorrect. And he wanted to set that straight. So on that Saturday, he made his mom breakfast. And much of the same that they do on a Saturday. She's sitting on the couch for that and went about the day. Sunday came, and again, much of the same. Breakfast in the morning, but he said, Mom, eat less. She did eat less, and it was Super Bowl Sunday. I'm not really into sports, but I understand that that was a really big deal that Falcons were in the Super Bowl. And on that Sunday, Mr. Rooks did have something to smile about. It wasn't that he was happy about what was going on for his mom. He was happy because the Falcons were in the Super Bowl. That was Mom's favorite team. He had the Falcons clothing on. And very important to him was that Cameron called and said, hey, Dad, I'll drive over if you pay for the gas and come over to our cousin's house or your cousin's house. He was happy. He was excited. It's not illegal to take a selfie video of that moment. And he probably made the relief. This had been going on for a long time. That little snippet of excitement and happiness was helpful for him to get through. And remember, he chose not to go to the party that was further away. I can't remember where it was right this moment, but I know there was testimony. He chose not to go to that party that was further away. He decided to go to his cousin's house because it was like 10, 15 minutes away, so that he could go home when he needed to. And he did go home. He went home early at halftime that day. The state's trying to say that he's a bad person because he took the video and was happy for that short moment, but this is a lot. Jim was heavy. But he was not correct. He left at time, went back home and went to bed. And his mom was there on the couch like she usually was. Now, Monday was not the same. This is now Monday, February 6th, 2 days before Madoka died. Lilia said to us, I tried to feed her soup and she had trouble eating. She spilled it on herself. I gave her some wipes to clean it up. She didn't eat much, but he had to go to work. And when he came, and she was sitting on the couch when he left. But when he came home and opened the door, there was something stopping the door there behind it. It was a cushion from the couch. Now, he didn't know if the dog had put it there or if his mom had put it there, but there was a cushion on the floor. And when he looked over to help his mom, he saw that she was wedged and she was off the spot that she was usually sitting on the couch. This was different to past times where she was on the wood. She was deeper into the couch. She had lost her seating move. So he went over to pull her up, and that was not gonna work. She moaned. So what he thought is, all right, I'll help her come up, but push the couch up like one of those power lift chairs that you see advertised for folks that have knee issues. It's to gently put it up. And that's what he did. Now that day on Monday, the 6th, his mom was on the floor. She had been partially covered up. He put a blanket on her and she was resting now on the floor. On Tuesday, February 7th, he heard his mom snoring and heard her sleeping. And he wanted her to just completely rest. Again, she wanted to die in her home without intervention and not in the hospital. And of course, we know she died sometime overnight on Tuesday or morning on Wednesday, when we found that she was cold. Now, the state talked a lot about the 911 call. Why did you say it was a non-emergency, Mr. Rooks? Well, for him, it was a non-emergency. She had told him 2 weeks before, I'm going to get up on out of here. And he knew what that meant. It wasn't a surprise that she was going through the dying process. This disease had affected her for years. So when he called 911 and spoke to dispatch, we heard that Sharon Lappin was custodian of the 911 tape. We heard him say it's a non-emergency. There were a lot of witnesses in this case, and you asked a lot of really good questions, most of them or all of them. The law enforcement came on February 8th, and there were the first responders. And that was Hector and someone that the state chose not to bring to you in this case. We don't know what that person would have said. So Hector took the stand, and I believe that he was actually the most credible officer out of law enforcement that the state presented to you, ladies and gentlemen. Now, it's true, he said that he was a rookie at the time in 2017, but he looked at the situation from the most reasonable perspective. Before he had gotten indoctrinated to look through bias glasses, homicide lenses, like Gilbro and Lee Packard. Hector said, Mr. Rooks was visibly upset. He was upset. He said he was up and down. He looked upset, then tried to pull together, then looked upset again. And he agreed with Mr. Korn on cross. People grieve in different ways. We all know that. We all know ourselves. I'm not going to grieve the same way as you do, or as you do, or you do. Everyone grieves in different ways. And we even heard about how people grieve in different ways during jury selection. Some of you may remember the young woman who talked about not wanting to hear about her family's illnesses until right before something bad may happen. She said, I don't want to know, I don't want to have to grieve too early, or something to that effect. It just makes the point that we all grieve in different ways. And many of us have dealt with family members dying, some suddenly, some prolonged deaths, and many from dementia. And we all grieve differently related to those deaths, and we all show emotions in different ways. We saw a glimpse of how Hilius showed emotion yesterday. It was difficult for him. He was on the verge of tears several times, but forced them back. Everyone grieves and emotes very differently. That's just human nature. But Pectel also talked to us about two other points that I want to bring up for his testimony. He talked about the dog. He sounded like an expert on dogs in the end. But he said, yeah, the dog was locked up when I got there. When the dog was let out, he was happy. He was like a puppy. He was happy to see everyone, friendly, and just glad to be around people. He wasn't a ferocious dog out to get people, like the state wants to portray it. He was a puppy, like a year and a half to 2 years old. And Mendoza loved dogs. The dog was her companion throughout this. The other thing I wanted to bring up, and again, Pectel had the most reasonable outlook from the get-go, ladies and gentlemen. He said the only reason he seems suspicious, or things seem suspicious, when Hilius asked about life insurance. But Pectel did follow up and say, hey man, why are you asking about life insurance? Are you worried about having to pay for the funeral? And these funerals happen very shortly after someone dies. And they would do it on credit, and they're expensive. But Pectel didn't follow up with any of those questions with Mr. Rooks, did he? The next law enforcement officer, or actually the medical examiner, was Gilbrow. Now, actually, Gilbrow was kind of straight up with us. He said, I presume every scene is a homicide until proven otherwise. Every scene is a homicide until proven otherwise. Gilbrow's totally biased. He looks at a scene to make pieces fit in through his homicide glasses. Completely unobjective. He sees homicide everywhere. He said it right there. And Liam Packer is the same. Liam Packer. He had no empathy for Hilius Rooks. How difficult things were for him, despite Hilius telling him how hard it was for him. Hilius answered all of his questions. He made some mistakes about the dates that I've already talked about, but he was stressed out. Even if he didn't show it, even if he emoted differently than all of us would have. Maybe it's because he's a man, I don't know, but he was stressed out. Didn't get the dates right, and so much was going on. He was trying to process as best as he could with his limited abilities. However, Liam Packer showed no understanding for this, and he was not objective at all. At least Gilbo said, yeah, I presume every scene is a homicide. Liam Packer didn't say that to us. He sat on the witness stand, gave his testimony smoothly, almost smugly in a way. Smugness. Like, I got this. Even in his responses to Judge McBurney, when he was on the stand talking to the state, smooth, polished, a professional witness, providing his narrative over and over again. never answering the questions that Mr. Korn was asking on cross. He don't answer those questions. He just wanted his narrative to be heard over and over again. Homicide, offenses, ladies and gentlemen. And he said, I put this in quotes in here, I wasn't screaming at Mr. Rooks. He said to co-counsel, I was objective. That wasn't true. If you remember, Mr. Korn replayed that part of the interrogation. And only after then did he say, oh, well, thank you for playing that audio. That gives me an opportunity to say, to see that my volume did go up. That is nonsense. He was screaming. Liam Packer became unwound with Mr. Rooks and lost all objectivity from the get-go. He wasn't objective, he wasn't professional. You know, I was thinking about all the research and that pretty slideshow that the state put together for the financial transaction piece of everything, and about this compilation of that research. And ladies and gentlemen, that was also biased. That wasn't a full picture or a complete picture. He prepared them again in a biased way. He only pulled out the information about Julius's dad's pension checks that were deposited, which were gifted by Medotha to Julius, that were endorsed by Medotha. She wanted him to have that money from his dad. He hadn't forged any documents or any checks. Liam Packer focused on these withdrawals. He did not look at the whole picture. He didn't talk about the large sum of money for the water bill, $5,000. He didn't talk about the amount that had to go to the ambulance bill because she didn't have any insurance. And he didn't talk about Julius's settlement that he got for the back dented of the PT Cruiser that you can see in the picture. Liam Packer, ladies and gentlemen, didn't talk about the property taxes that were involved in this case. Those were large sums of money, not so much on the North Avenue, which is like $100. That was incredible. But the other three properties, $1,000 per property, $3,000 a year. Now he focused on, the state focused on through him, this, I think it was like 32 months or something, maybe just less than 3 years. He didn't talk about any of those expenses. And not only did Medotha owe money on the property taxes for the current years, but we heard from Julius that she owed back taxes for the prior 3 years. This is important information. Was that in his report? Did we hear anything about those expenses? Again, homicide lenses, ladies and gentlemen. Now, we also heard from several lay witnesses. Let's talk about Jacqueline Williams. Do you remember her? That's the ex-girlfriend from 20 years before the time involved in this incident. 20 years before Medotha died, they dated. Williams had no direct knowledge of what was going on for Julius's family. She said, that's her testimony. She said even when they dated, she rarely went inside the house. And once the relationship ended, the little she saw of Julius was at a park, not far from the house. She never went by the house after they stopped dating. This is all her testimony. The state talked to her about some conversations that were had, some half conversations from her perspective, because she could not hear what was going on the other side of the phone. And talked about that he was, frustrated or yelling or upset with his mom. Williams doesn't know anything about what was going on for them in that point in time, or even surrounding that point in time. She also suggested where she also testified about her suggestion to Hilius. And the state asked her, well, hey, did you give any suggestion to Mr. Rooks about what to do with his mom and what kind of care? She said, oh yeah, I did. Sure I did. I suggested that he ask his cousin Anthony to help with Mendoza. Do you guys remember what cousin Anthony said on the stand? He said, I couldn't help with her. I couldn't help with her. He said it himself. Because he was busy taking care of his own mom and his 4 grandkids during those years. He couldn't. He had no time to help with Mendoza, even if he wanted to, is what he said to us. He didn't have any idea what was going on with that son. She talked about the house not having central air when we heard that it had window units, 3 out of 4 work, and 1 of the basement doesn't work. We had air. She talked about she thought that Hilius had a power of attorney over his mother's affairs. Also not true, ladies and gentlemen. We heard from the Wells Fargo custodian of records. I can't remember that person's name right at this moment, but we heard from them and also from Hilius yesterday. There was no power of attorney on the record, in those records. You're gonna have them back in the jury room. You look through it. There was no power of attorney. Williams got that wrong too. And the state also elicited testimony about this wad of cash for Williams. Again, she had no idea what was going on with Hilius at that time. She had been out of his life for a long time. A long time. She didn't know what he had brought in related to his side gigs that he testified that he would get cash for. We never got into the why they broke up or why she may want to testify against him, but you can just imagine, like a Reader's Digest novel, the story would go. This is someone that was not in his life for years and years. And lastly, I think the state talked to her about this full protective service call, but never did the state provide any proof of any substantiated claims of abuse by APS, by Adult Protective Services. In fact, Duante Thompson, who was here, he said, I spoke to her through the burglar doors. Mendoza looked through the burglar doors and didn't see anything of concern. That's what he said. Then there was Catherine Alston, the longtime neighbor, who again is pretty attenuated from what was going on in the family. She talked about a time when she was helping her mom with health issues. Do you remember that? She mostly talked about that, and she said that happened 21 years before Mendoza had died. That's the time frame when you did the math with the years. You rely on your own recollection, but it's 21 years before that she was in and around the house more so to help her mother through those health issues. Austin wasn't focused on Mendoza. She said herself, I was in and out of the house for years. I got married, then divorced, then married again to Angela Hammond, the ex-APD officer. She said she'd go a couple times a week. She was really busy with her full-time job and raising her children. Now, the one thing she did testify to is that she did notice that after Jimmy died, Mendoza's husband, she didn't see her outside very much and guessed that she was depressed. She mentioned to us, ladies and gentlemen, that she spoke to Mendoza through the barred door even as early as 2012. And maybe this was just Mendoza's way of talking to folks through the burglar door. Because you remember when the cousins took, at least Vincent, when he took the stands, he said he would speak to Mendoza through the door prior to Jimmy's death. He didn't stop by often, he said, but when he did, he never came inside the house and he spoke to Mendoza through the door. Dementia is tough. And let's face it, no one stepped up for Mendoza except Asadel, her sister, and Hillis was on consistent basis to check on his mom. And again, it's unfortunate that Asadel passed, so we can hear her perspective. But Mendoza was one of 9 children. No one else, I know that we heard that some of them had passed by this time, but the ones that were still alive were stepped up. And one of them even started, robbing her house after she died. We heard about Elston. No one stepped up. Austin was on the sidelines, and there had been even a falling out. Police talked about there was some kind of gun incident. We didn't get into that, but there was a falling out between the families. He didn't confide in her. Cousin Anthony was too busy. Vincent, he said, he never offered to help her. He knew he couldn't because he had to work. He couldn't volunteer, and he never offered to clean up the house or the yard work, I think is what he was talking about. Phileas Rooks did the best that he could do. Now, the state showed you their evidence, the photos and videos, and they showed some of them over and over again in different contexts. The law enforcement talked about the same narrative over and over again. There's a reason for it. This case is emotional. I mean, I feel it too. It's emotional. They want to make an emotional imprint on your minds through the photos and the video. The case is emotional because it's involving a parent and a child, which is a very special relationship, a very serious relationship. And because of the dementia. Dementia takes all of a person's faculties from them. A lot changes when someone is going through dementia. People with dementia, they come and go in the way they behave. And I think even Billy's talked about that, the coming and going in terms of his mother's behavior. He talked about her having some good days and some bad days. He talked about strange behaviors, about the walking at night, which is very common for someone that has dementia. The strange behaviors that were shocking. If his mother understood that she was doing them, she'd be horrified. These were very strange behaviors and all part of dementia. He said that she would take her diapers off. He had diapers in the house. There was a box of them, and he tried to have diapers on her. She would take them off. Again, not unusual. Many of you have experienced family members or loved ones in front of dementia. These are not unusual behaviors. Unfortunately, the spectrum is wide with that disease. Some people can be calm and peaceful, other people can be violent. Some people exhibit strange behaviors like Medusa did. And she said to him in her more lucid moments, I wasn't doing that. So he thought, maybe not the best idea, but he thought that he would document it with photos or videos. But he also told us, no, I did not show those to her. I didn't expect anyone to see them. I didn't show them to her because it would have made her more depressed. And most shocking, probably that Medusa had these serious bed sores. And there's no denying that the photos are horrific. And again, it elicits an emotional response in us when we look at tough images, no matter what those tough images are, because we're human. But unfortunately, most people with dementia get bed sores. It's very hard to combat them. Even people in assisted living facilities, we heard that even during jury selection, the one woman who had worked in New York at some kind of facility, state facility, where she talked about, yeah, I saw people there with bed sores and ulcers. Sure, I did. These things happen in assisted living facilities. They happen when someone's in hospice. Hospice doesn't even provide any intervention. They're there just to help the person die. But the photos and the videos make us feel emotional, ladies and gentlemen. And being a juror on this case requires you to separate out from that emotion. Separate out from the emotion. Took an oath, the judge administered an oath to be fair and impartial, to be unbiased when you evaluate the evidence. This case requires you to separate out, to set those emotions aside. It's not easy, but it's required. To evaluate the evidence through unbiased, fair, and impartial lenses. Now, the judge is going to instruct you on the law. We talked about that just before starts talking to you guys. And he's going to tell you that the state has the burden of proof, the only burden of proof. And actually, he's mentioned it throughout the trial. The full burden is on the state. And they must prove each element of the charge, in this case, beyond and to the exclusion of every reasonable doubt. You've probably heard that on TV. Some of you, I think, talked about watching crime shows during jury selection. Beyond and to the exclusion of every reasonable doubt that you may have in your head once you're back there in the jury room. Now, there's language in that instruction. It's not to a mathematical certainty, and I'm guessing that the state will focus on that. I'm not sure what that really even means. Many of you are teachers, so you could probably figure it out better. But reasonable doubt is just that. It's a doubt that you have reason to believe something else could have happened. Something else could have been true. It's not just that you're pulling it out of somewhere, it's that you have a reason, a basis for that doubt that's lingering in the back of your minds at the end of today. And it's based on your common sense and experiences, or it's based on the evidence, the lack of evidence, and the conflicts of the evidence. Those are the places that give rise to reasonable doubt, ladies and gentlemen. Your common sense. I think Judge McBurney talked to you from the get-go. Don't leave your common sense at the door. Your experiences. It wasn't random that you guys were chosen for this jury. We talked to you during jury selection. You were chosen because you have some experience that is related to this case. Don't leave that at the door. The evidence presented. So reasonable doubt comes from common sense, your experiences, and the evidence presented. That's the witness testimony that we've been talking about so far, and the exhibits and the reports. You'll have all of that back there when you start talking about the case. The lack of evidence, what the state didn't bring to them. Some of these witnesses, the one officer, the first responder, the lack of a complete report related to Mr. Rooks' finances, lack of evidence, and any conflicts in the evidence that you recall as you recount what you've heard from all the witnesses during the course of this trial. So those are the places that reasonable doubt comes from. Those areas. And after you've considered all of the evidence in the case, if you still have this wavering concept in your mind, this wavering unsettledness, you likely have a reasonable doubt related to the charges in this case against Mr. Rooks. And it's kind of like a lot of lawyers give examples like this. Like if you're packing for a vacation, and you're trying to get the whole family together and deal with the dog, get the pet sitter in place, and you've ironed an outfit, and you leave the house, and then 20 minutes into the ride to wherever you're headed, you're like, oh my goodness, did I forget to turn the iron off? Did I or didn't I? It's that kind of feeling that's going on in your mind, that wavering feeling. Of course, in this case, your jurors are. This case is not about any household funds. It's not about an iron or a coffee machine that you may have forgotten to unplug. This is about Phineas Brooks' life and liberties. Ladies and gentlemen, Phineas Brooks did not scream his mother. He did not forge any checks. There's no evidence of that. The checks he received from his father's Mass Mutual pension account were a gift to him. Adoka endorsed the checks. He would use his money for his own benefit. There is no evidence, and this is the lack of evidence part that gives rise to the reasonable doubt. There's no evidence that Hilius was living a lavish life between 2012 and 2017. He had the PT Cruiser. He didn't have multiple vehicles. He didn't have a Tesla. He wasn't living a lavish life. He was working every day just as he had for 20 years at Georgia Tech. And before that at ESPN, the place that he worked at before that. He'd been working his whole life. He's a regular working guy. There's no evidence that he took wild trips. I mean, there was nothing said about him even going with his mother after her retirement on the trip. She went with her, the friend that was, I forget the word, the term he used, but she liked road trips. He wasn't going on any lavish trips. Did he live in an expensive house? Was there any evidence of that? We had Jay take the stand, and also Hilius talked about sharing a bucket apartment. Now, and the state went on about the rent increasing. We all know that rents are increasing. He wasn't living any place glamorous. He was sharing an apartment with a roommate, always paying his share of the expenses. His share of the expenses for the utilities, his share of the expenses for the rent, working every day, Monday through Friday, and making some extra spending money from his side dish. And he did use his mom's money for her bills. And there was testimony about that. He paid his mom's utility bills. He paid that large water bill. Ambulance bill. Multiple property tax bills annually. He bought her groceries, household products, diapers, even though she'd take them off. He used her money for her bills and her expenses. And at no time did he use her money for his own benefit. Ladies and gentlemen, the state is also charging him with unreasonable confinement. They're alleging that Adoka was confined because of this burglar door. The burglar door. First of all, the doors had been on there. It's not like Rooks put them on the house. They had been on there from the beginning. His father had them in place. And there were 3 doors to the house. One from the basement that leads to the yard. One we saw in the picture, and we specified that on the picture that leaded to the side, where the Bronco or the truck goes over there, and the front door. And we heard that these doors locked with a key, or they could just be the mechanism, the sliding mechanism for locking from the inside. Liam Hacker said to co-counsel, to Mr. Korn, I didn't check any other door. Lack of evidence, ladies and gentlemen. They're focused on the one front door. And furthermore, there was testimony about Madoka Rooks always forgetting her keys. Now her purse, Lily's told us yesterday, her purse was always either in the living room or in the dining room. It was never. And always in her purse with the keys to the car and the keys to the house. And I think Cameron even said that to us. And he also talked to us about her forgetting that she had her purse, that she would forget about the house and car keys. And that was part of his thinking in terms of, I don't think I should take grandma out anymore for grocery shopping. She's forgetting all these things. Things are chaotic. She doesn't remember. And then there's Nigel the dog. I already talked to you. That's one of the allegations the state is making in terms of this unreasonable confinement. Madoka loved dogs. She was practically breeding them. We heard that it started years before, and the state said, well, did that end years before? But we heard about the different litters that came up through the years all the way to 2006. She liked dogs, and actually she really loved Rottweilers. I mean, that was something that she had shared with her son years before. She liked dogs. And police got the dog to try to make her less depressed, to be a companion for her. The dog wasn't, again, ferocious. They talked about that the dog was barking and scratching on the door. Well, no kidding. There's a ton of people in and around, a lot of commotion, probably smells and sounds that dog hadn't heard. But when you heard from Pectel, we heard from Pectel, Officer Pectel, the dog was like just a puppy. He was happy to be out and around people when they let him out, and that's true. Well, this wasn't unreasonable to find his mother. Julius Rooks did not murder his mom. He did not murder his mom. There was no evidence presented by the state that he had the intent to murder his mom. You heard from Julius yesterday, Mom was my best friend, my first friend, he loved his mom. We heard from Jay, his longtime friend for years. Those were his mom. He would ask me to take food over to her when she had days off. And he had to work like he worked every day. She felt like she was part of the family. Went to the funeral, Virginia's funeral. They had a good relationship. I think the best. He did not have any intention of murdering Madoka Rooks. There's been no testimony of intent, and there's been no testimony of causation. The judge is gonna give you the law later on, and you're gonna get to see all of the elements and read about causation. But Julius Rooks did not cause his mother to die. He did not cause it. The state presented an expert, I don't know if you remember, because it was like early on last week, Dr. Diana Homier. She's the one that recently moved from Los Angeles to Atlanta, you know, and they brought her in to write or they paid her to write a report for them and their interest, and to testify in the case. And she talked to you, I don't know if you remember this, but she talked to you about the research that she had conducted and that she believed to be true. About her research. Did she do any independent research on this case? Absolutely not. I don't know if you remember when Mr. Korn talked to her. She had done no independent research. So researcher did no independent research in this very important case against Mr. Rooks. And of course, she was getting a check from the state to be here, $2.50 an hour, and that's what she said. She recently moved, so I'm sure that was part of the calculation. But she didn't do any independent research. she basically, she cut and pasted, it's a cut and paste job, she cut and pasted the same narrative that the state repeated through their law enforcement. The same narrative. Most of the report is a cut and paste job. And even at the end of that, she said, there was no evidence, she couldn't talk about the cause and manner of the step. She didn't know what the cause and manner was. It wasn't convincing. State also brought Dr. Henninger. That was a tough day. That was the day where we saw the photos, the autopsy photos. This is not. And those were tough to see. But if you recall, and again, I don't actually remember if it was during cross or direct, Dr. Henninger talked about a list of ailments that Mendoza Rooks suffered from. Clinical history of dementia, number 1. Mildly atrophic brain, like I pronounce all of them. Cerebrovascular atherosclerosis, left ventricle hypertrophy, focally moderate coronary artery atherosclerosis, pulmonary embolism in the right pulmonary artery, superficial ulcers in the gastric mucosa, diverticular disease of lower and large intestine. All of these things, a whole list of medical issues that he's listed here. And he told us that any one of these could have caused her death. Any one of the long list of health issues that Mendoza suffered from at 83 years old could have caused her death. And he talked about how things were discussed in his office, right? You guys remember that? He said, yeah, we talked a lot about this case. This case was discussed by my colleagues in depth. And the majority of us, the majority of them, because he said he wasn't in that group, did not believe it was a homicide. They did not believe it was a homicide, which is why in his report, manner of death, it's undetermined. Now he made some reference of some political agenda going on back there, which I have, he didn't elaborate on, but at the end result was there was enough discussed and understood for people in his office, professionals, medical examiners, to say that the manner of death is undetermined. It does not say homicide, it says undetermined. And think about it. If the Fulton County Medical Examiner's Office could determine the manner of Mendoza Rooks' death, how are we supposed to? You're going to get a lot of law. Once the state finishes their closing, and it's not by design, I mean, it is by design, it's not by chance, it's by design that they get to go last and have the last word before you all. But you're going to receive multiple jury instructions. And the one we implore you to focus on is the involuntary manslaughter based on a lawful act. You will have the jury instructions back there in the jury room with you. In the case of involuntary manslaughter based on a lawful act, state must prove the defendant caused the death of another without intending to by committing a lawful act in an unlawful manner that was likely to cause death or injury. Mr. Rooks did the best he could. Take care of his mom in the best way he could. He did not do anything unlawful. He did the best he could. If you believe that that's what most accurately reflects what Mr. Rooks did or didn't do, then the law requires you to find him guilty of involuntary manslaughter based on a lawful act. Ladies and gentlemen, when Hilius heard his mom say, his mom was here first, I'm gonna get up out of here. I'm gonna get up out of here. He knew the end was near. He was overwhelmed with the task emotionally and psychologically. He did not intend to harm his mother. He did not have any intent to murder his mother. He had no intent to unreasonably confine her or exploit her like the state's would suggest he did. And he had no intent to do anything unlawful towards his mother. And I don't know if you remember this, it's very powerful. He said, it was just me by myself. Everybody passed on and left me there trying to do it. Everyone else went away, talking about his brother and his father. With his limited experience and capabilities, he did the best that he could at that time. Hilius honored his mother's wish. She died at home. She did not die alone. After reviewing the evidence in this case, ladies and gentlemen, we're going to ask you to find him not guilty of all cases. Thank you so much.
Thank you, Ms. Jenks. So, Ms. Hilton, at some point during your closing, we're going to take a break. Do you have a spot where you'll go for a bit and it's a natural transition, or would you prefer for me to say, hey, let's break when I perceive you're moving from topic A to topic B? Or
Surely, I think there's a natural break that I can make, but I am going to ask for a comfort break very quickly before us.
okay, well, why don't we, we'll take a short break, 5 minutes, ladies and gentlemen. You're welcome to stay. Well, you should just go to the jury room. We'll get back in here 10:51, 10:52. That'll allow the state to get their PowerPoint ready to go if they're doing that. And Ms. Hilton to take her comfort break, which some of you may need as well. Don't talk about the case. We'll see you in a moment. Ms. Russell, anything from the state?
No, Your Honor.
Ms. Jenks? All right, we'll be on a brief break. Mr. Anjurin, you just come in to spectate, or did you have, you got my email? That was me. We need to figure out an angle. I don't know how we do it. We need to mount a camera up there that captures the lawyers when they're giving their closing arguments or their opening statements. I guess we could move that a little bit and it would, but then it's going to sort of scoop the jurors a little bit and you're getting the side of them. But for, I think, every courtroom, something that is mounted behind the jury box, projecting downward, that's a big project. Pardon me? Okay, but hey, new team member. Fantastic. So you can be the one who installs those cameras behind every jury box that captures the lawyer. There's just, it's not an angle we can get. You know, we can get the back of the lawyer if we spin that around, but then we're getting all the jurors. And I guess if we could hijack or patch into the sheriff's camera right there. Yeah, it's not urgent. It's just, I've noticed that from trial to trial, the fan base watching will say, hey, we can't see who's talking. And the only way to capture it is to pop that one on, but you sweep, as I said, some of the jurors. that's not an issue. People could be in here seeing the jurors, but if we're broadcasting, it's better to have it be lawyers and clients rather than jurors. Otherwise, things are working well. We'll have to work through this cloud-based versus local Zoom because the YouTube thing just wouldn't start up yesterday.
Actually, no.
She was open. She wasn't walking for the last. She stopped
Okay.
walking maybe 2 months.
I'm happy to still guinea pig it. We fixed it, so we'll come back to it. All right.
But there was one day you came home.
The last time she walked was like 2 months ago or something, about 2 months. Last time I've seen her walk.
Yeah, and then when the last time she walked, did you come home when she's on the floor or something like that?
Yeah.
Okay, so then you see her on the floor and she never walked again after that?
Nope.
Okay.
Was on the sofa.
How did she get to the bathroom?
Right there where she sit. And then I used to hear her saying,
Well, take me through like the past 12 months. What's been going on? But there was one day you came
She
home.
wasn't walking for the last.
she walked was like,
Let's see. She stopped walking maybe 2 months.
2 months ago, she stopped walking ago?
Yeah.
She stopped walking around? Okay. But there was one day you came home.
the last time she walked was like 2 months ago or something, about 2 months. Last time I've seen her walk.
Yeah, and you said it was around 9 you went to sleep last night?
Yeah.
Okay.
Friday.
Let's go over the timeline again. So you get home Friday, there's my son, you have a conversation with your mom.
Right, see?
She's on,
Oh, I'm gonna hide it. Yeah, we got it. It should pop up. Okay.
Ms. Rivers, you ready? Ms. Hilton, are you ready?
Yes, Your Honor.
You've been comforted?
I have been.
All right. Ms. Jenks, anything before the jury comes in? Let's bring them in, please.
All right, adjourn. Ready.
Thank you, Deputy Gordon. Ladies and gentlemen, you've heard the closing argument summation from Mr. Rooks's team, and it is now time for the state's similar presentation. Ms. Hilton, when you're ready.
Thank you, Your Honor. Good morning. We started this journey a week ago. And it was last Thursday that I stood up before you and I told you, this defendant failed to honor his mother, but succeeded in giving her death. This defendant left his mother in inhumane conditions. This is the woman who birthed him, who loved him, who gave him life, and he gave her death. I sat and listened for the last hour as defense counsel said he was overwhelmed. He had no help. He did not know what to do. And that's just a lie. It is a bold face. It's just a lie. You heard the evidence in this case. You saw the witnesses testify. You saw the pictures. This defendant had help, had knowledge, and what he did is he intended to neglect his mother, to confine his mother, to exploit his mother, and to murder his mother. That was his intention. And as I sat and I listened to the defense counsel, I'm reminded of a story.
About the remote that doesn't work?
Exactly.
Yeah,
Which was
it's a
just working
bad
5 minutes
story.
ago. Okay. I got it. It's working now. Okay, here we go. And here we go. So there was an individual who worked border patrol. And he worked border patrol for a number of years. And as he got to his retirement, he decided to go out. And he saw an individual that he used to see a lot when he was on border patrol. And the guy that he would see quite often in his time working border patrol was a young man who would ride a red bike every day across the border. And the young man every day would have a basket with some sandwiches. And the border patrol guy always felt kind of suspicious about his red bike. This guy walking across. to the right. So he would check the guy often and say, what's going on with this red light? What's going on? And every time he saw the guy cross the border, he would look in that basket, and he would see something. And this happened multiple times. So now that he's at the retirement party, really it was at a bar, he saw the guy who had a red light. And he says to him, hey man, today's my retirement. And something's been fishy with you all these years. I don't know what it is. I'm retiring, so you're not gonna get in trouble, but just give me my curiosity. Tell me what was going on with you and that red light. The guy was like, man, enjoy your retirement. Don't worry about it. Doesn't even matter anymore. The night keeps going. The guy who's retiring is drinking a little bit more. He says, hey, guy, tell me what you're doing. I'm drinking. I'm probably not gonna really remember what you tell me. You're not gonna get in trouble. But tell me what's going on. Like you had this red light. I kept looking in the basket. I kept saying, tell me what's going on. I was like, don't worry about it. Here, let me buy you. End of the night, Border Patrol is kind of drunk now. A lot of people have been buying him drinks. He's like, look, I'm probably not going to remember. I'm going home to sleep. Just tell me what was going on with that red light. He's like, the guy was like, you know what? You're probably not going to remember, so I'll tell you. You know, every single day when I was coming through Border Patrol, you always kept looking in the basket for something. And it was always same. But I was just smuggling in a different red light every day. See, you were so focused on what was in the basket, you wasn't focused right in front of you. Now, ladies and gentlemen, I know you all are not like the Border Patrol guy, and this is a case that there is no really sand in the basket. This case is clear. This is a clear case of neglect. But if there are some of you who are like, maybe he did treat his mother in the best way. If there are some of you who think maybe he was overwhelmed, let's talk about what the sand in the basket is. So the first thing that the defense counsel, or not the first, but one of the things she talked to you about is we didn't bring in one police officer or a certain police officer. Well, why is that sand in the basket, ladies and gentlemen? Well, the defense has to do nothing. They stay cloaked in innocence. They don't have to bring a witness. They don't have to do anything. They really can sit there, be quiet, and not say anything. Everything that comes that you need that we have to prove. This table has to prove everything. But in this case, they decided to put on a case. They put the defendant and they put Gennaro. I submit to you, if that other police officer was gonna say something different than what you already knew, he would have been here. He would have been here. That officer did not add anything to this case that you didn't already know. That's sand in the basket or sand bias. Police bias. Liam Parker was biased. Investigator Gilbo was biased. How? When Investigator Gilbo told us when I go into the house, I do make because it was a house because I don't want to contaminate the scene. But I'm looking to see if there's anything that can help support one way or the other. What did Investigator Gilbo say? Well, when I came in, normally on elder cases, I don't have to call the homicide unit. In my 20-something years of being an ME investigator, I had never seen anything that looked like this. And then what did he say? The first thing I looked for was some diapers. And we're gonna get to whether or not there's some diapers in the house. He said, I didn't see any diapers. She was laying with holes in her body. Holes in her body and flies coming out of it. And he says he was being biased. No, he came onto a scene and said, this is not normal. I done picked up a lot of elders, and this is not normal. But he's biased. Leah Parker said consistently, I wanted to believe that someone would not treat their mother this way. I wanted to believe that Mr. Rooks was going to tell me something that did not make me think that he did this. But yet he was biased. You know what he kept on doing too? He didn't just take out a restaurant on day one. He said, well, let me keep on investigating. Let me keep on saying, because I really don't believe someone would do this to their mother. But yet we're defining it as bias? No, it's defined as investigation. It's defined as looking at a scene and saying, there's something not right. What else? Oh, she wasn't unreasonably confined. She just enjoyed for the last 4 or 5 years staying in the house and talking to people through the door. That doesn't make no sense. And we're going to talk about unreasonable confinement. Well, she has dementia. So her dementia must make her think, or she couldn't really help herself. I think they're trying to say like she did this on her own. But you know, if she has dementia, you should be taking more care of her, not less. But she didn't want to go to the hospital. She didn't want to go to the nursing home. She didn't want to do anything. Ladies and gentlemen, we all were in jury selection. Some of you, or you've heard other jurors say, at times, initially on, I had family members with dementia. They didn't want to go, but we convinced them to go. We talked to them. We realized it was in their best interest. And some even said, even when they didn't want to go, we still took them, and they got better. When they got there, they decided it was in their best interest. So this notion, like, oh, well, she told me 1 time, 2 times, as she was deteriorating and declining, you don't say, you know, mama, I hear you, girl. I know you're gonna be mad at me for a little while, but let me call that rehab place that daddy went to the first time that he liked, and let me see if they have a program that I can take you to. No, you didn't do that. You didn't want to. Sand in the basket. And these 3, he honored his mother. If this is honoring, we don't want it. This ain't it. Honoring in death would be something like Addison, laying at home in a bed in hospice care. Or like your daddy in a nursing home. But having your mama on a floor in the middle of the winter time is not honoring her. I dare you say that he was honoring his mother. He was overwhelmed, but yet he spent 40 to 50 hours at the music studio making beats. But you overwhelmed. How? And he did the best that he could do. But asked none of the people who were willing to help him for help. Did he ask Janara for help? He helping her, but not his own mama. Sand in the box. I always say, what is true is often forgotten for what is convenient. So what I thought was real convenient with Ms. Jinx, she didn't talk about neglect or felony murder. She didn't talk about it. I was listening. And she was talking about what we had to prove. She didn't talk about neglect or felony murder. Why? Because everyone can see. Ray Charles could probably see, smell, and hear that this is neglect. That's why she didn't talk about it. But we won't talk about it. So let's talk about the defense case. So they brought you Miss Ahmed. Well, I don't know if she's really helpful for that. You know, they wanted to bring Miss Ahmed in to say, well, he took care of me, so he's really taking care of his mama. No. No. He took you to medical appointments. He called your doctor for you and never did it for his own mother. The lady who gave him life, he didn't do it for her, but he did it for a stranger. Let's also talk about what Ms. Ahmed said. That he paid half the bills. And even when he moved out, he paid the bills. But we're gonna talk about how much money he was making. Because ladies and gentlemen, he was only making about $1,300 a month from Georgia Tech. You heard, we're gonna go into more detail. So how you pay half of her bills? You paying for your studio time. Where you get all that money from? Oh, and he would pay her in cash. Probably that cash he was taking out of his mama's bank account. These extra jobs, a lot. Like I talked about, he would help take her medicine, take it to the doctors, refill her prescriptions. Did none of that for his own mother. She told us that she last saw Ms. Rooks in September 2016. And she was fine. We was having a great conversation. Well, ladies and gentlemen, that video y'all saw, that was a horrible video, was in November of 2016. We know that she was in a steady decline, according to them, starting really from 2012. So she wants y'all to believe that 2 months before we see her on the ground, that she just say, oh my, we have this great conversation. That doesn't make no sense. She said the defendant would clean their apartment. Clean their apartment. Well, Mr. Rooks has been, according to him, living with his mom before her death for at least 2 months. He ain't clean her apartment. Ms. Rooks couldn't walk, and we're gonna talk about that. So he cleaned the stranger's apartment because really they know each other for 30 years, but she's not your family. You can clean her apartment, but you can't clean your mama's apartment. Or do what Cameron did, pay somebody $2,000 to go clean it up since you don't want to do it. You got the money. Even if you're getting gifted your daddy's check, you spent $18,000 on something, then spend $2,000 on your mama to clean her house, the house you grew up in. All right. And again, like we said, she said he took care. So let's talk about Hilliard's Rooks' testimony yesterday. Because he just lied. He just lied. Up, down, all around, he just lied. So we just gonna take some of the key ones piece by piece. So yesterday he testified, I had baby wipes and diapers in the living room next to the couch. Ladies and gentlemen, tell you it's gonna be a part of this where you're gonna see Ms. Rooks on the floor, but I want you to look at the areas around the couch and see if you see some diapers, okay? It's paused. There's no diapers there. We pause it again. There's no diapers there. So you don't have to see Ms. Rooks. We kind of blacked it out. If you need to watch the whole video, it's in evidence. There's no diapers in the chair or wipes. Top of the table, no diapers. Maybe it's in the Amazon box, no diapers. Maybe they're in the cabinet somewhere that she can't get to. there are no diapers. None. In that house whatsoever. Because you would think, if he done put his mom on the couch since 2012, if there's gonna be some diapers, they're gonna be in the living room, right? It ain't no diapers there. He a liar. Let's keep going. The dog was my mama's companion. Let's hear what he says.
And then I used to hear her saying, stop fighting me, stop fighting me. Know what that was. Okay. No, that's that damn dog. He wasn't really biting, you know how you play, biting and shit.
The dog got a companion, but he biting him? This is not even him being interviewed. Oh, and this is right after he's supposed to be grieving for his mama's death. He on the phone talking to a number of people. I think that's about 30 to 45 minutes of him talking on the phone. Oh, this one. My mama must have signed the form for me. I ain't signed it. Remember, we was going back and forth. Is your name Hilly is Rooks? Does your first name begin with an H, your last name begin with an R? Oh, but that wasn't me. My mama signed that for me. When she just got out of the hospital? That doesn't make any sense. Why are you lying? For what reason? Oh, this was the best one. Well, I didn't see my mother walk, but I heard her wandering around the house for the last 2 months. So in 60 days, you have never seen your mother walk? Only at night when you sleep? Well, let's hear what it says.
Well, take me through like the past 12 months. What's been going on?
She was up and she wasn't walking for the last, let's see, she stopped walking maybe 2 months.
2 months ago, she stopped walking ago?
Yeah.
She stopped walking around? Okay.
As we said, 2 months ago, she stopped walking. Not, she stopped walking, but I think I might have heard some sound in the back. Oh, but he says it again.
But there was one day you came home.
The last time she walked was like 2 months ago or something, about 2 months. Last time I've seen her walk.
Yeah, and then when the last time she walked, did you come home and she's on the floor or something like that?
Yeah.
Okay, so then you see her on the floor and she never walked again after that?
Nope.
Okay.
I put her on the sofa.
How did she get to the bathroom?
Right there where she sit.
Did you hear him say anywhere in there? Well, I used to hear her wandering at night. He said, this 2 times Leah Parker asked him now, when the last time you seen your mama walk? It was 2 months ago. But now yesterday, because it looks bad when your mama ain't been walking in two months and you don't take her to the doctor to find out why your mama not walking no more. When I asked him about the prescription, he said, did you check Publix for her prescription? Why would I do that? Let me tell you why I wouldn't. She ain't been to the doctor since 2014. Who gonna write the prescription? Who gonna write it? There is no prescription at Publix. Maybe he was thinking about Jannar. Maybe it was Jannar's prescription at Publix, but it wasn't his mom. So no, I didn't check it. The lies that he's telling. He started to make plans to place his mother in a nursing home. No, you didn't. If you remember back in opening statement, which is not law, which is not evidence, what they said was, well, we didn't want to put her in a nursing home because it's such a bad experience that they had had with the father. So, why now all of a sudden you started thinking about putting her in a nursing home? Oh, and you keep saying she didn't want to die, she didn't want to go anywhere. So now we started looking? No, I had to say that to this jury because I'm looking a little crazy for keeping my mama on the ground. And you know what else he knows? That if I put my mom in a nursing home, I'm gonna have to pay some more money. So that $102,000 that's in my mom's savings account, and I'm the next of kin, I'll get it. I ain't trying to get into that money. So I'm not gonna put her in a nursing home. Or maybe her monthly checks would help in her care, and I gotta keep stealing her money, and she don't really know what's really going on in her bank account. So I'm not putting her in a nursing home. That's taking away from my check. Mom said, I'm getting ready to get about it. I'm ready to get about it here throughout these. He wants you to believe that was her saying, I'm ready to die. No, she probably wanted to get about that sofa. She probably, because remember when he said her butt was irritated. Mama told me her butt was irritated. So maybe she wanted to come up out of the sofa you had her in, at least we know since January 31st. Maybe that's what she was ready to do. She wasn't ready to die. Some of you might be familiar with Notorious B.I.G. This is not a Biggie album. No, she's not ready to die. She didn't tell you about her life insurance policy. So she's so ready to die, and you can communicate with her at times. Why would she tell you whether or not she had a life insurance policy? Where it was, how much it was? Let me tell you why. Because you and your mom never had them conversations. It don't make no sense. Oh, and this is it. Let's talk about the new timeline. All right now, the timeline yesterday changed because he was so confused. And when he saw the interview, he was like, oh no, I'm confused. Let me change it. All right, so let's talk about the new timeline. February 3rd, he stopped by the grocery store. Mom said, do you need a hand? What would she say? She can't walk. How she gonna help? But he wants to add that in sleep rights. He got her meal together. She ate soul food. I think that's the day he said she ate real good that day. Then she went to Piccadilly. He went to Piccadilly, got her breakfast. She ate, but not like Friday. Then on Sunday now, Super Bowl Sunday, she was sitting on the sofa and he fed her breakfast that morning. On Monday, he got up, took a shower. Mom, she ate soup for breakfast. She spilled the soup. He gave her paper towels and he went to work. Then on Monday, he came home from work, saw the sofa on the cushion floor behind the door. She was down in the sofa. He then turned the couch over, and this was the best one. He eased her out. That's what he said. He eased her out. Then he drank a bit of water on Tuesday. She drank a bit of water. She was on the floor sleeping. And you can see down here, the last one says, on Wednesday, he found her deceased. That's what he told y'all yesterday, right? Now in front of the jury, now when he has 5 years to think about it, now when it looks real, real bad that you left your mom on the floor after yanking her body and leaving her with an orange, this is the timeline. Oh, and I was grieving so much back in February 2017, I just forgot this timeline. So ladies and gentlemen, like I pointed out to him yesterday, he told several people this version, his initial version. So let's hear the first time to Detective Lynn.
You said it was around 9 you went to sleep last night?
Yeah.
Okay. All right.
She had stopped speaking about 2 days. The last time I spoke with her was Friday. When I got off work, came through the door, she said, there's my son. You know, all excited. And then I was telling her about the fact we was in the Super Bowl. Sunday, I left to go watch the Super Bowl. And I told her, matter of fact, I told her I loved her and all that because she had stopped speaking. Saturday, she was stuck in that sofa. That's why I left everything like that. I even got pictures of her stuck down in there. When I pulled her out, I think she had been there and got fused or something, but you know, her skin came off with her. And I laid her right there on the floor, and that was the last time she talked. She talking, oh, Jesus, you know, like she was in pain and stuff. Jesus, Lord, she kept saying that.
Did you call an ambulance or anything when that happened?
I knew she was being stiff because she kept her leg always crossed.
Yeah.
Is it crossed now?
I don't know. I just got here, so that's why I'm about to go see.
When he asked her, did you call, when technically if I asked her, did you call 911? What he said, I mean, I do that. He didn't respond. But that's the first time, and that's not even the first time, ladies and gentlemen. Remember, he had told Officer Peck all that. But we don't have that recording, right? But Officer Pectel, which we all believe is credible, testified that he gave me the timeline. And remember, Officer Pectel is the one who initially told Liam Parker about the timeline. And Liam Parker initially said, well, let me confirm. So let's talk about the second time. We talk about the timeline.
So Friday, when I got off work, she said, "There go my son." I thought everything was good. Okay. Saturday is when I pulled out that sofa. Felt like she was fused to it. So I pulled out the sofa and laid her right there and left the sofa tilted up. Well, I don't know, man.
That's not even talking to law enforcement. That's him in them 45 minutes before police officers ever come in. I believe he's talking to Peggy on the phone. So now, and he real clear, he don't look distressed. He don't look like he grieving. If you can recall, all these conversations that he's having is him trying to tell everybody, I don't know why they got me here. Let me tell you what's been going on. But now all of a sudden, oh no, I saw the video and I got the timeline wrong. Okay, so let's talk about the third time.
Let's go over the timeline again. So you get home Friday, there's my son, you have a conversation with your mom.
Right, feed her.
She's on the sofa, and she's probably, your skin doesn't fuse to the sofa overnight.
But she's got, what you call it, man?
Dementia,
She
that's
can't
fine.
tell me that.
Saturday?
She did say my butt was stinging.
Okay, Saturday morning,
Complaint she.
morning, day, or night did the sofa incident happen on Saturday?
That's the third sofa now.
Okay, but morning, day, or night did you lift up the sofa when she came out?
No, I'll move her over because she be laying.
Morning, day, or night on Saturday?
I'll sit up, shift her, put her in a different position.
Was it in the morning on Saturday? Was it during the middle of the afternoon, or was it at night on Saturday that happened?
More like the morning.
Okay, so in the morning, she goes onto the floor, and she's there.
I put her on the floor.
Okay,
I
you put her on the floor, okay. And she's there in that same place on the floor today, right, where she was on Saturday morning?
She was in another position this time. How was she, like on her side?
Yeah.
What was she doing with that hand?
She hasn't gotten up and gone to the bathroom. She's in the same spot, right?
Right.
Yeah,
Right.
she hasn't moved. She's immobile. She's in that
What
spot.
was she doing with that right hand?
I don't know. And then when I got there, it was already after fire rescue had come to try to take a look at her. I heard that she was covered up with blankets when you found her this morning.
Keep them flies off of her.
She wasn't covered up.
Keep her warm. I knew she was.
She
naked.
wasn't covered up when I got
And
there.
that night time she wasn't. They did that.
That's my point, is that you're asking me how she was. I don't know how she was because I got there after other medical personnel got there, the fire department.
Because I think between Friday, it got dipped down in it got real cold.
Okay, so that was Saturday.
That's why that blanket was on.
Sunday, you're talking to her about the Super Bowl, but she's not talking back.
No. I only told her that we were in the Super Bowl.
On Sunday.
No. Friday when she was talking.
Okay.
Mama, we in the Super Bowl. I came up, there's my son.
Tell me
Some
about-
small talk. Mama, we in the Super Bowl.
Did you?
You know, I'm talking to her as I'm feeding, preparing her food, that kind of stuff.
Did she eat anything on
She
Friday?
had a little bit Friday.
Okay. Did she eat anything on Saturday?
Thursday, she pigged out.
Okay. On
But she was spilling it all on her.
on Saturday, did she eat anything?
She when he talking, then she just, she did say, oh, Lord, that was all she said. Before I was talking, I said, you all right? What's hurting? She didn't say nothing.
On Sunday,
Sunday, she didn't say nothing.
Didn't say.
She was snoring.
okay.
That's why I ain't disturbed. She was down there snoring, sounded like she was sleeping good. I didn't know her.
Did you say earlier that you left for the Super Bowl on Sunday?
I went and saw the Super Bowl.
Where'd you go watch that at?
Over my cousin's house, down by the Blue Flame. You know what the Blue Flame is?
Yeah. Mm-hmm. Over on Bankhead, Harwell?
Back there. I was supposed to be going way out, but I didn't want to go far. I don't ever go too far from her. That's why I accepted that job at Georgia Tech. I took $11 pay cut so I could be near her and say, in case something happened, I could zoom, probably walk home.
Yeah, and then Monday. Tell me about Monday.
Monday. Still sleep.
Okay.
You know?
Still not eating.
No, she wasn't. She was asleep. Snoring, rather.
Okay. And you went to work on Monday?
Yeah.
You came back?
And went to work, and ooh, it was a mess. And then when I came home, I saw her moving around a little bit.
Yeah, she's not eating. When did you give her that orange that's lying next to her? Was that Thursday she picked out,
That
Friday
was
she
that
ate
was
some,
Saturday, when she was up and aware.
but she wasn't really up and aware on Saturday, right? That was when you pulled her off the sofa. It was,
She was talking about, oh Lord, ooh.
right, yeah, and that's when you put it there for her on Saturday?
Yeah.
Okay, but she never ate it, okay. So Monday, she's pretty much just snoring and sleeping. And then Tuesday, you go to work? She awake when you leave?
She wasn't awake. She was still breathing and snoring and moving around and that kind of stuff.
Moaning?
She wasn't really moaning. She was like, let me see if I can. It wasn't a moan.
Okay.
More like something,
Yeah. So Tuesday night, you get home from work, Tuesday afternoon, yesterday, right?
Yeah,
4:30, 5 o'clock?
about 5.
Okay. And still, she's not conscious, she's not
You could
talking?
tell she was in a different position because I think her hand was like this time.
Okay.
But this hand right here, always, I knew what she was doing. She was probably digging in her butt. I don't know. Yesterday she was like this. The other time she was like that.
Yeah.
And she was like this.
And what time did you go to sleep on Tuesday, last night?
Probably about 9.
Okay. And you could still hear her
Yeah.
breathing, snoring?
When I hear her go clear her throat or something, I jump up, I go look. I ain't slept in maybe a week or so. Slightest little noise, I go check.
Yeah.
And
then,
when I open the door, go in the living room, then I can hear the.
And then what time did you wake up today?
About 5. My clock is set for 5. I go peep on her, go in there, take a shower. Then I'm ready to feed her now. I got myself out of the way because she be about to cause you to be late. So I got myself together, I feed both of them.
But not today, you didn't feed her today, right? She hasn't eaten in days.
I ain't feed her since Friday.
Right.
Friday was the last time she
Saturday, you left the orange for her, right? But she hadn't really truly eaten since
I said,
Friday.
since she didn't eat, then I'll leave this here for her. She could eat munch on.
What did she eat on Friday?
Soup. She ate vegetable soup. She ate.
Was that soup that you made for her, or is it something you picked up like you said?
Canned soup.
Okay.
Progresso and Chunky.
Ladies and gentlemen, he even corrected Detective Liam Packard during his overview of the timeline. But yet he wants to tell you yesterday that, no, I got it wrong. No, you didn't. No, you didn't. You got it absolutely right on February 8, 2017. But you know it is absolutely horrible that you left your mama on the ground for 5 days after pulling her off the couch. And she's screaming, oh Jesus, oh Jesus, oh Jesus. That is horrific. And you know that. That's why you gotta change your story. No, this is what happens. And cruel, his actions are cruel. My mom was my everything? This is what he told you yesterday. But you failed to give her any care. When talking about his brother, I couldn't get out of the chair because he couldn't breathe because his brother died in his arms. But you driving around on Super Bowl Sunday, piecing up, smiling, taking selfies. while your mother laid on the ground with holes in her body, stuff oozing out of her body, and flies out of her body. And he didn't want to abandon his mother? That's exactly what he did. He was entrusted with her care, and he abandoned her. But he wants to come and tell you these lies. My mom always said to me, actions speak louder than words. His actions are inconsistent with his words. So let's talk about the law. Because Judge Bernie's going to give you some charges, and defense counsel trying to tell you that this is not murder. Well, we're going to talk about the law right now. So I'm going to tell you what this is not. So you're going to get a charge on accident. Accident is no person shall be found guilty of any crime committed by misfortune or accident in which there was no criminal scheme, undertaken, or intention or reckless conduct. An accident is an event that takes place without one's foresight or expectation, that takes place or begins to exist without design. That's a lot of legal stuff, so we're gonna break it down. So what is committed by misfortune or accident, or an event that takes place without one's foresight or expectation? I submit to you an example of an accident. It's driving down the street, you're following all the traffic laws, you're not speeding, you're not on your phone, you're paying attention, and a child bolts out in the middle of the street, and you injure that child. Ladies and gentlemen, that's an accident. You're driving down the street, you're paying attention, you're doing everything you're supposed to do, but a child bolts out. That's an accident, ladies and gentlemen. This is not an accident. So you're going to get a verdict form. Well, accident won't be on there. This is not an accident at all. This defendant didn't accidentally fail to take care of his mother. He intentionally failed to take care of his mother. He intentionally decided not to get her help. He intentionally decided not to seek help from those who are willing to help him. This is not an accident. The next charge you're going to get is an interesting charge, but it's involuntary manslaughter in a lawful manner. So what you're going to get when you get your verdict form, and what the court and the judge is going to instruct you on, is there's going to be 2 involuntary manslaughter. And when you go to the back, you have to consider one, and depending on what you decide on that one, which is lawful manner, will determine if you can consider the other charges in the indictment. So for this lawful manner involuntary manslaughter, you as a jury can either decide if you think it is involuntary manslaughter.
I'm sorry, I have to object. This is entirely wrong. That's the wrong statement of what the instruction is. It's the wrong statement of what the verdict form states, and it's not the law. I have to object, but this is wrong, and it's been up there for a while.
Okay, ladies and gentlemen, you'll be receiving the law from me. You will have it not on the screen in someone's PowerPoint. You will get this jury charge. You'll have this copy. If you need more copies, you can have more copies. That's the law you'll get. The attorneys are free to summarize what they think the law is that I'll be providing, and to apply what they think the law is to the evidence that they are sharing with you.
So you're going to have to choose one. So you're going to have to consider the first one, which is lawful manner and unlawful manner. And so when you look at this involuntary manslaughter, what you're looking at is a person commits involuntary manslaughter when that person causes the death of another human being without any intention. So that's going to be really important. By committing a lawful act in an unlawful manner that was likely to cause death or serious bodily injury, right? So it has to be without intention, and it has to be a lawful act in an unlawful manner. So let me give you some examples. I think this is the kind of essence. Say you have an electrician and he puts an electric panel in the home without a permit. So to put an electric panel in the home is lawful, but he did it in an unlawful way, which is without a permit. And the house catches on fire and someone dies. That would be involuntary manslaughter, lawless, in an unlawful manner, right? You did a lawful act, which is putting the box in, but without a permit, which is unlawful. And so you didn't intend to kill anyone, didn't intend, this kind of just happened. That would be an example of involuntary manslaughter, unlawful manner. Another example would be two people go deer hunting. You have a license to go deer hunting, you go take guns, you're in lawful possession of your weapon, but you do it out of deer hunting season. There's only a certain time that you can hunt deers. And when you do so, maybe you go out deer hunting and you try to shoot a deer, but the person you came with dies. And it's not like a setup murder, it's not like something I'm trying to kill them, but it's really an accident. That would be involuntary manslaughter, unlawful manner, right? So those are kind of two examples for the process when you're in the bank. This case is not that. Because I submit to you that he didn't just negligently take care of his mother or recklessly take care of his mother. He intentionally decided not to take care of his mother. He intentionally decided not to give her care. He intentionally decided on Saturday, after he yanked her off the couch and pulled her body, not to call 911. So all of his actions are intentional. This means it was unintentional, not intentional. It was involuntary. Ladies and gentlemen, I submit to you that when you go in the bank, you're going to say no. You're going to X this out. Do not consider it at all. Now, when you decide not to consider that, then you can consider what we're going to talk about next, which is going to be confusing. Because I'm going to ask you to check not guilty on that, because he's not guilty of that, because he didn't do that. We're contending that is not what he did. So we're going to charge not guilty on that. And then you're going to move to the second involuntary manslaughter consideration. So the second involuntary manslaughter is based on reckless conduct. And so what does that mean? The state must prove that the defendant caused the death of another without intending to do so by committing the crime of reckless conduct. Again, it's without intention. As I submitted to you a few moments ago with the other involuntary manslaughter, Hilliard's Rooks intended all of his acts. And by committing a crime of reckless conduct. So what is reckless conduct? Reckless conduct occurs when a person causes bodily harm to or endangers the bodily safety of another person by consciously disregarding a substantial and justifiable risk that his act or omission will harm or endanger the other person. And the disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in this situation. So that's a lot of words, so I like examples. Examples of involuntary manslaughter or reckless conduct. You're playing with a gun, maybe, cleaning it. Cleaning might be the other one, but you're playing with the gun, you're not pointing it at anyone, but you're in a room, you're playing Russian roulette. And the gun goes off. You didn't intend to kill anybody, you didn't intend your actions, but you're recklessly playing Russian roulette. The gun goes off to kill somebody. Sorry, some people are pointing at it. That is involuntary manslaughter, reckless conduct. I don't intend to kill anybody, but the manner in which I'm handling this weapon is reckless. I shoot someone and I kill them, and they die. Or an example is you're playing with a friend and you're pushing your friend. You're pushing them and you end up pushing them real hard and they go into the street and a car hits them. You didn't mean for your friend to get hit by a car, but because you're pushing them, you're acting recklessly and they go into the car and they're hit. That is involuntary manslaughter, reckless conduct. You didn't intend for it to happen, but your reckless misbehavior caused it. Ladies and gentlemen, I submit to you that what he did to his mother, it was inhumane. It was a disregard. So ladies and gentlemen, he intended to treat her that way. This isn't an accidental thing. He didn't just wake up one morning, all of a sudden his mom has decubitus ulcers, and now all of a sudden we're reckless. No. You intended to not to provide her health care. You've known for 2 months she could not walk. And you did nothing to figure out why your mother wasn't walking anymore. You knew she had holes in her body. That's why you closed the door. And we're gonna talk about what Kathy Austin said. Because you did not want anyone to see your mother like that, because you didn't want anyone to save her. You intended your actions. So ladies and gentlemen, I submit to you, this is not involuntary manslaughter. So when you get that, you're gonna put a big X. No, you're gonna check not guilty. So when you get your verdict form and you're gonna see it, you'll check not guilty. Now let's talk about what it is. And you're right, this could be this not.
Anyone need a break? Let's keep going on.
Okay. This is what it is. Let's talk about your duty. What you're instructed to do here. So you have a duty to follow the law. So you are to be a fair and impartial juror, honestly seeking the truth. You are not to seek doubt. You heard us talk a lot about that in jury selection. You are bound by the instructions and the law given to you by the judge. Each of you have a duty to deliberate. If you go in the back and one of your numbers says, I can't do this, I ain't looking at no picture, I'm not talking to you all about it, I'm going in the bathroom, y'all tell me when y'all finish. You need to bring this to the attention of the judge. You each have a duty to deliberate. You each have a duty to talk about this case. I know it's long, but it's important. So you have a duty to go in the back and deliberate. What are you not to consider in this case? You're not to consider passion, public opinion, that you're unhappy with the police, any public feelings, any sentiment. I'll first have sympathy for the defendant. They said he tried to come up here and cry yesterday. I didn't see it, but no sympathy. And while this is an egregious case, really no sympathy for Ms. Rooks. It's all about the law and facts. Okay. That you disagree with the law, any conjecture, not to consider penalty or punishment that is not for you to consider, keep that out of your mind, and prejudice. But what you can't consider is what's inside the circle. The law that the court is going to give you, the testimony of the experts, specifically in our case, we had Dr. Diana Homier and Dr. Henninger, testimony of the witnesses, elements of the crime, your common sense. We don't actually leave that out of the door, just your common sense from your natural life, just live it. And any motives to lie. Who had the biggest motive to lie? Him, the defendant. He has the biggest motive to lie. And you can consider it. So what are some legal principles? So the presumption of innocence. Your Honor, ladies and gentlemen of the jury, because the defense does not have a verdict, his presumption was done, when we rested. Because they don't have to do anything. So I submit to you, when we rested yesterday, he was guilty.
Judge, I'm going to object. That's also an incorrect statement. While the jury is the determiners at this point, not the prosecution's rest.
Okay, correct statement of the law. As I've told you before, you all will decide if the state has met its burden by proving beyond a reasonable doubt whether Mr. Rooks is guilty of one or more of the crimes charged.
When the state rested. Some of you, when you hear what happens, they ask, is he crazy? No. This is what the law says. Every person is presumed to be of sound mind and discretion, although this presumption may be rebutted. You have no evidence that it was rebutted. There's nothing here legally to say, oh, he was saying he was this. No, that's not this type of case. You may infer that the acts of a person of sound mind and discretion are the product of that person's will, and that a person of sound mind and discretion intends the natural and probable consequences of those acts. He understood what he was doing. He chose to do it. He intended to do it. Burden of proof. You hear that a lot. So what does that mean? It rests with the state to prove each material allegation of this indictment and every essential element of the crime charged beyond a reasonable doubt. A reasonable doubt means just what it says. It's reasonable. It's based upon common sense and reason. It is not vague or arbitrary. It is a doubt for which a reason can be given. And we're not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. So you can't say, you know what, all doubt, no, it's reasonable. You need to be able to look at your member and say, I don't think he's guilty because it has to be reasonable. And a reasonable doubt is a doubt of fair-minded, impartial juror, honestly seeking the truth. What happened in the years, months, and days leading up to Ms. Mendoza's death? What truly happened? And again, you are not to seek doubt. So let's talk about evidence. So direct evidence, you're going to hear about two types of evidence, direct and circumstantial. So direct evidence is evidence that points immediately to the question at issue. It's your testimony from your witnesses. So when you hear Dr. Henninger testify, or when you heard Catherine Alston testify about what she said about going over to the home and not seeing Ms. Rooks, those are testimonies that point directly to the issue. Like I said, what they saw, what they heard, any pictures. So we have a lot of pictures, and we're going to go through some of them. I will tell you that, but you have the pictures here. The medical examiner's testimony. All those things are direct issues to talk about the direct evidence to talk about the issues in this case. And then you have circumstantial evidence, which are proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. So I like examples, so I'll give you another one. So say if you leave here, if you're like me, your car is like a little on empty, and you have to go to the gas station. And when you pull up to the gas station, you pull up your car to the pump, you turn off the engine, you open up the gas tank, you step outside, you put your card in the machine, and you take the pump out and select your brake. You then put the nozzle in the tank and you begin pumping. You smell the fumes. You see the numbers going up, up, and up, and up. It stops. You take the tank, you take the nozzle out, you put it up, you close the tank, you get in your car. It goes from empty to full. Now, what's your direct evidence that you got gas? You went to the gas station, you could smell the gas. You were able to drive off, you weren't buckling. The numbers kept going up, right? So those are all direct pieces of evidence that you got gas. But the question is, did you see the gas go into the tank? You didn't. But you took all of those direct evidence and you inferred that gas went into the car and not some other substance like sugar. So you take the direct evidence and you can infer, make reasonable inferences. So what's circumstantial in this case? That this defendant took his mother's card, had access to her bank account, was taking her money. When she's lying on the ground, he's Googling what happens when your mom dies. How can you see what happens when your mom dies? What happens to her bank account when your mom dies? Never Googling 911. You can infer that his intent was not to get her care. Why? He wanted her money. He didn't want to get her no help. He never Googled any life-saving measures. He never Googled any nursing homes. He didn't do anything to help her life or prolong her life. So you can take those kind of direct pieces of evidence and make a reasonable inference to the conclusion. That's kind of circumstantial evidence. Now, witnesses, ladies and gentlemen, I'm not going to go through every witness individually, but we're going to talk about the witnesses as it relates to the crimes, okay? But we heard from a number of different witnesses. And what I want you to know is the testimony of a single witness, if believed, is sufficient to establish a fact. So if you take Ms. Alston as credible, you saw her, you saw how she testified, her manner, and when she says to you that Ms. Rooks was locked inside the house, she has no reason to lie about that. You can believe that without us showing you a door with a key on the inside. You decide which witnesses to believe. You decide to resolve any conflict without believing a witness made a false statement. You decide their manner in which they testify. You decide their interest or lack of interest in this case. And you decide their opportunity for knowing the fact that they may testify. I keep talking about intent, ladies and gentlemen, because it's a very important concept in this case. Intent may be inferred from the proven circumstances or by acts and conduct, or it may be inferred when it is the natural and necessary consequence of the act. An intent can be formed in an instant. And like I said before, a person of sound mind intends the natural and probable consequences of his or her actions. Ladies and gentlemen, he intended not to provide her care. It's his intent. He chose not to do it. And again, criminal intent does not mean he intended to violate the law. He intended to commit the act. So let's talk about the case and the crime charge. Let's go through a little timeline to kind of recap the case. So facts in 1960s, that's when the Rooks moved into 1251 North Avenue, which is in Atlanta, Georgia, Fulton County. They were neighbors with Catherine Alston. In about the 1980s, Ms. Rooks retires from Atlanta Public Schools. And somewhere, in the early 90s, early 2000s, Ms. Rooks was living a vibrant lifestyle. We know that in 2006, Addison died at home in hospice care. And we know that in June 2012, Jimmy Lee Rooks died in a nursing home. And also in there, probably in the early 90s, we know that Jimmy Lee Rooks retired, family in the house. We know in March 2013, Ms. Rooks goes to Atlanta Medical Center because she fell. She was found in urine and feces, and her sister Osadell takes her. The hospital informs Hilliard, that his mother needs full-time care. That's that piece of paper that he said he didn't sign. We know that the last time Ms. Rooks ever sees her primary care physician is in 2014. We know that in 2015, Ms. Rooks had to go back to Atlanta Medical Center. We know somewhere between 2013 and 2015, he gets a dog, and we submit that that dog was purchased to prevent Cameron and Osadell to come home. We know somewhere in 2013 and 2014, Catherine, Jacqueline, and Anthony all offered to assist Ms. Rooks. We know that 2013 and 2014, there are APS reports. In 2016 of November, the defendant takes that video of his mother and also takes pictures of his mother playing in her ex-room. We know December 2016, somewhere in January 2017, she fell and could not walk again. And he never called for any care. That January 31st, 2017, that's when he takes that picture of Ms. Rooks stuck in the couch. Somewhere, well, on February 1st and February 4th, that's when he's doing his Google research. What happens to my mom's bank account when she dies? What happens when my mom dies without a will? There's flies around a dead person's body. What does that mean? There's swelling around her body. What does that mean? And never gets her any care. On February 4th is really, according to the defendant, he pulls Ms. Rooks off the couch and she yells, "Oh Jesus, oh Jesus," and he fails to call 911. We know on February 5th through 8th, the defendant goes to the Super Bowl party. He comes back and forth, stepping over his mother's body or walking by her body for 4 days. Even when she stopped talking, he doesn't say, "My mom ain't been talking in a couple of days. Should I get some help? She ain't woke up in a couple of days. Should I call somebody?" No, he back and forth to his room. And then eventually on the 8th, when he comes outside, she's now cold to the touch and calls 911. Now, ladies and gentlemen, this is a 5-count indictment. He's charged with murder, felony murder, neglect of an elder person, exploitation of an elder person, unreasonable confinement of an elder person. And what I'm going to charge you with, ladies and gentlemen, is starting from the bottom of the indictment to the top. So starting with count 5 and working your way up to count 1. And you're going to get an instruction that you need to look at every count individually. So you consider count 5, you deliberate, you find him guilty, you move to count 4. Everyone talks, you deliberate unanimously, find him guilty, move up to count 3, and so forth. So start at the bottom and kind of work your way to the top. So that's how I'm going to explain the law to you, starting from the bottom of the indictment and working your way up. So what's count 5? Count 5 is unreasonable confinement of an elder person. So what does the state have to prove? When a person knowingly and willfully unreasonably confines an elder person. So we have to prove that it was knowingly, willingly, and it was unreasonable, and the person was an elder. So the easiest part of the elder person is a person over the age of 65. We know Ms. Rooks was 83 years old. Proof of unreasonable confinement. Catherine, Cameron, and Jack all told you she did not have a key to get outside that house. Catherine said she would go over and visit Ms. Rooks, and Ms. Rooks could not open up the door for her. I submit to you, this is your neighbor for 50 years. There'd be no reason for Ms. Catherine to lie if Ms. Rooks could get out to speak to her. Why wouldn't she? She wasn't a stranger. Jacqueline says, the reason why I called APS is because he was leaving his mama in the house and she couldn't get out. And she was afraid that something might happen to her. Ladies and gentlemen, she could not get out of the house. What did everyone else say? He never allowed anyone to come inside. What did Jacqueline say? When I would go over there, he would come outside to the car. Vincent said the same thing. He would come outside to the car and get food and take it back inside. Why? You had this door, and you had the other door. We're going to look at the other door in a minute. And what's interesting, that remember what Catherine said, that she went over there maybe a few days, maybe the day before Miss Rooks is found, or 911 is called. And she said, I knocked on the door, but what was odd is both doors were closed. And that hadn't really been happening. Usually the wooden door would be open and the burglar door would be closed. But on this day, both were closed. And remember what she said, which I thought was very interesting, was, I thought maybe she was in the back bedroom. Miss Catherine didn't even know or realize that Hillies had pulled his mother out and that she'd been laying on the couch for at least 5 minutes. There's no reason for her to lie about the fact that this defendant kept his mother locked in that house. Now, I don't think it ever came out on the stand, I'm almost positive, but if it did, that there was a key in the house. I don't think it came out in evidence. Remember, you can only consider what came out on the stand. But ladies and gentlemen, even if there was a key in the house, how is she gonna get to it? She can't walk, at least for the last 2 months. The key's not sitting next to her on the couch or on the floor, so how is she gonna get to it? Oh, what's the other thing that he says? Well, she's having dementia. I got the dog so she's not running around on the street. So why would you keep a key if you don't want her to open up the door and getting out that she got dementia? There was no key for her to get out. That's what you gotta think through, right? It doesn't make sense. What's the other door? So you had the door in the kitchen that was obstructed with a trash can, a dog bowl, and a broom. He treated that dog better than he treated his own mom. But she couldn't even get out that door. Why? Because again, for at least the last 2 months, she's immobile. So even if she wants to get out, she can't make it to that door either. Maybe she could crawl, but it doesn't appear that's what she was doing because she was stuck on the couch. So she can't get out of that door. And it's not like there was someone there taking care of her during the day, like Anthony offered to do, who can maybe help her get out the house. And then there was the third door out downstairs, but she can't get downstairs. She can't go down the steps. She's immobile. So any of the doors that have access, she has no access because she can't get to them. He unreasonably confined her. And when Anthony said, hey, cuz, can't come every day, but I can come some days, he didn't take him up on the offer. When Catherine says, hey, I can maybe help you try to find some care, he didn't take her up on that offer. She could not get outside of this house. She was in jail in her own house and had no way. She was unreasonably confined. And we just talked about it. This not Burger King, you can't have it your way. You can't say, well, she got dementia, so I don't want her to get out. But then say, yeah, she had a key to get out. No, she didn't. And you didn't even take her out. You didn't even take her out. Cameron took her out. You didn't even say, Mama, it's stinking here, the dog been pooping in here. I know you got some stuff, so let's go get some fresh air. Let me drive you around the block for a little while. Let me take you up to my Buckhead apartment. Mama, my house is dirty, so I know you don't want to go to a nursing home, but why don't you come up here to Buckhead with me in Gennaro? And now that we moved from a 2-bedroom to a 1-bedroom, maybe you can stay in the 1-bedroom and I can stay in the, and me and her can stay in the other bedroom. Did he do that? No. No. Guilty. Check. When you get back to the verdict. The jury. Next count is count 4. Like I said, we're moving up the indictment. Exploitation of an elder person. When a person knowingly and willfully exploits an elder person. Again, knowingly or willfully exploit. So what's exploit? Illegally or improperly using an elder person or that person's resources through undue influence, duress, abuse of access, or other similar means for one own or another person's profit or advantage. So let's talk about it. So Hilliard's Rooks, what we know from the record, is that between July 1st of 2014 and February 27, 2017, he made somewhere between $32,500 and $52,000. Remember, Leon Parker testified that most times it was about $659 that he was getting every 2 weeks. Some weeks was $500, some weeks was $800, but generally it was about $659. What do we know? He had Ms. Rooks' credit card, her bank cards, both her bank cards. What do we know? On the day that his mom was on the ground, and he pulled off the couch and he couldn't call 911, he going into her bank account, take $300. What do you also know? While she's lying on the ground, he's depositing a check, which I assume that she was still supposed to go to her, into his account. He cared too much about the money. Remember, we went through all the totals. This was the last total. He stole $18,000 from his mom. This notion that, oh, she gifted it to me, but yet she was psychotic. But now all of a sudden, when she got to sign the check over to you, she's not psychotic anymore. She understands what's going on. No, she doesn't. She's not going to her bank account. She's not checking her bank account regularly to realize that you've taken, in only the amount of time that we got the account, $50,000. That $18,000 that he was depositing in his bank account from the pension checks. She's not going and looking at her bank accounts anymore to realize that every check she endorsed, maybe she thought he was depositing into her account, not his account. He wants you to believe that she was gifting him this, but then tell him about the life insurance. That doesn't make sense. In the course of those 32 months, he took out $50,000. Let's talk about, and it was holding it in cash. Isn't it ironic that Jacqueline Williams, if y'all remember, I showed Jacqueline Williams' picture, right? And she's like, I think that's his hand. And we were like, no, and I remember, I said, I'll wait till later on to bring the picture in. And before I showed her the picture, she described how he carried the money. And what did she tell you? that prior to him taking care of his mother, she never saw him with wads of money. He used to keep his money in his wallet. But after, that's when she started seeing him with this in the park. And isn't it ironic, the same thing that Leah Parker said? Y'all heard the shock in Leah Parker's voice when he pulled out the money? He said, oh, damn, or Jesus, I don't know what he said, but he was shocked. Why are you carrying around almost $3,000? Oh, because I was getting ready to buy her dress, but you hadn't left the house that day. So you were prepared for a funeral, but didn't have the life insurance? But you were gonna use this money to buy her dress and your suit? No. He was stealing the money and walking around with wads of money in his house. Using it to do what? Pay for his studio. Keep on paying Gennara's bills that he was still paying. But not pay for any health care for his mom. He was using that money for his own benefit. And he wanted to tell you that he was paying all these bills. Ladies and gentlemen, you're gonna have in the bank those financial records. You're gonna see that in 2014, he paid approximately $1,400, maybe $1,500 for taxes in Jasper County. Then in 2015, he paid approximately $1,700. In 2016, he paid approximately $1,600. And in 2017, he didn't pay anything. You're going to see that if there's a property in Hancock County that he paid about $1,120 in 2014. In 2015, he paid taxes, which was about $1,125. In 2016, he paid taxes, which was about $1,063. And in Fulton, he was actually a little bit off. He only paid taxes in 2015 and 2016, and they were approximately $345 both years. When you total that up, and you start looking at how much he was paying monthly for bills, and even if you believe this notion that he was going to the supermarket, spending $200 every other day, that monthly does not total up to the amount of money he was stealing from his mom. Even going to Piccadilly's or K&S, that did not equate to the $68,000 that he ultimately stole from his mom. The $50,000 from her bank account, and the $18,000 that he was stealing to put in his daddy's check in his account. It does not. That is someone's salary a year that he's saying he's spending on taking care of his mom. No, he was stealing her money for his own benefit and his own use because he was only making $1,200 a month. Again, we talked about the studio. He ended up, remember what Cameron said, they initially were splitting the cost, but then after Cameron got the car, his dad had to take over the full payment. The defendant told you in his interview, he stopped using his money. He was living for free in his mom's house. That's a benefit to him. Like I said, I put bill, but paying for his Gennara's bills. And that his mom gave him those checks. What she did. You saw your mom don't know what's really going on. Let me take advantage of that. It's a paper check, so it's not going right into her bank account. So when you sign it, you ain't gonna know what I do that you don't come out the house. So you don't know where I'm gonna put the money. And you know, people lie, but they don't know. What did he say about his daughter? He said, oh, my mama wanted to give my daughter all the money. That's what he said yesterday. So why was she just putting that $648 in the account for her? It's not for you. You were stealing it. And you knew your mother would never know the difference. So deliberate, and you might have some other things, ladies and gentlemen. I'm only highlighting some evidence. You might have wrote something else down. You can consider it. You'll find him guilty. Count 3. The count that Ms. Jenks talked about. Neglect of an elder person. A guardian or other person supervising the welfare or having immediate charge, control, or custody of an elder person commits neglect of an elder person when that person willfully deprives an elder person of health care and necessary sustenance to the extent that the health or well-being of such person is jeopardized. So Hillius Rooks was the other person supervising the welfare, and he had immediate charge, control, and custody of his mother. He became her caregiver when he decided, 1, to start paying her bills, and 2, when he moved in. And when he was going back and forth. Although he didn't live there, he still had charge, custody, and control over her. Because he was taking care of her everyday needs. And definitely when he moved in. But it started way before he moved in those 2 months before. That he willfully deprived her. Ladies and gentlemen, we've been talking about it over and over and over again. He failed to get her any health care. He failed to get her insurance reinstated. He failed to seek Medicare or Medicaid. And even that, she had money in the bank. This is not a case, ladies and gentlemen, of some people don't have money. She had $102,000 sitting in a savings account. If he never stole any of her money, separate and apart from the 102 she had in the bank account, each check over that 14-month period would have totaled $100 and something thousand. That is $200,000 that he had that could have gave his mother medical care, provided for a nurse, bought some diapers. Diapers probably cost $20. He couldn't even spend $20 on his mother. He failed to give her health care. And any sustenance. He let her sleep on the floor and rolled her an orange like she was a dog. And he had the decency to peel the orange. Let me put it in your mouth, Mom. Let me let you eat it. He didn't have the decency to do that. For duty of care, the state does not need to prove that the defendant had a legal duty to provide care for his mother. For you to consider this, it only applies to a person supervising the welfare or having immediate charge or custody of an elder person. So what is your proof of neglect? We know that he supervised the welfare of his mother. That he had immediate charge, control, and custody. We just talked about it. He was her last living immediate family member. Mr. Rooks and Addison was deceased. He began taking over her bills. He brought her food to eat. And in 2013, he was the one who took her back home from the hospital. He had junk mail that he could have opened up. He didn't even open up any of these things that would have given maybe information on how to get Medicaid. He didn't have the decency just to open up the mail and say, you know what? I mean, look, they got some stuff on my Medicaid. Maybe I can call some of these people. Maybe I can call some of them and find out if I can get you some Medicaid. She had pill bottles for over at least 10 years. talk about what Dr. Henninger said about her swelling of her feet. If you just got her some care. We just talked about the money. This is what actually made it to her bank account. She had enough money for care. This is the amount of money that she would have had he never stolen anything from her. So I don't know nobody who got that in their bank account right now.
Judge, I have to object now. This has gotten way too emotional. I couldn't tell before when she was facing away, but the prosecutor is clearly playing on emotions, and that's an appropriate and improper argument.
Okay, thank you. Ladies and gentlemen, you'll be deciding the evidence from your review of the witness testimony and the exhibits that have been admitted, and not the passion of the advocates.
It is emotional. That's why the second Leon Parker started to get loud inside the interview. It is sad. You should feel something. He didn't feel any emotion
Objection,
for his
Judge,
life.
again, she's playing on emotions. That's improper argument.
Okay, I'm overruling that, and I'm going to let Ms. Hilton continue.
He felt no emotion for his mom. Not one bit. So let's talk about the deprivation of her and the willful deprivation. So first, in 2013, back in August, she's discharged from ANC with instructions that you all saw that he needed to make sure she had continuous care. We know in February 2014, Ms. Madota Rooks was last seen by Dr. Dow. That there was a check card payment in 2014 to Piedmont Healthcare. We know that she goes back to AMC in 2015. That there's another check card payment to Atlanta Medical Center. We believe maybe that is because her insurance had lapsed, but he paid that check. In 2016, that's when he's taking a video of her on the ground handling her feces. We believe sometime in December of 2016, because he said it was 2 months that she stopped walking. We know on January 31st, 2017, that is when he had his mother stuck to the couch, and he actually talks about this.
Well, she was wedged in that sofa. I'll show you that picture. I'm talking about literally wedged in the sofa. I had to lift the sofa up and tip just like you see it now. That's the only way I got out of there. When I pulled on it, I swear it felt like she was fused to it.
So that's when he knows she's stuck in the couch, can't get up. So that's January 31st. So that's at least probably 4 days before he even pulls her out the couch. He knew she was stuck in there. That's why he's taking pictures of her. Then we have from February 1st to February 4th, all his Google searches, and then Ms. Rooks passed away on the 8th. Let's talk about the last 10 days of her life. On January 29th, he's pulling $300 out of her bank account. On January 31st, he takes that picture. He goes back again to take another $300 out of her bank account. And ladies and gentlemen, also what's inconsistent with his news story, you're going to have his records in the back. You're going to see that in that last week of her life, he used to use bank cards to go to like the K&S and the Piccadillys. There's only 2 payments that week. One is January 31st, and maybe others around February 1st. There is nothing from February 4th, or 5th, or 6th. Or might be some wings one of those days. But that's the day I think he had the orange, that left over the orange. They get inconsistent with his news story. On Friday, February 3rd is the last time Ms. Rooks speaks. Okay, it's on here, February 3rd, he goes to Wing Zone and K&K Soul Food, but he gives his mom a canned soup. That's the day he gave her canned soup. On the 4th is when he takes her off the couch and leaves her on the floor with an orange to eat. On Friday, that's when, on Sunday, that's when he takes selfies. And from February 4th to February 8th, he gives her no cake. Not one bit. And she's dead in on the 8th. Now let's talk about Dr. Diana Homey here. I'm gonna go through this pretty quick because I think my time is almost up.
You got 26 minutes.
Thank you, Ron. What did she came in, that was our expert who talked about abuse and neglect, and she talked about this wheel and some of the factors you can look at. So you have one kind of way that the individual controls an elder person's abuse of dependence. He denied her health care, did not report her medical condition or problems. There was no walker in the house, no diapers in the home. Remember, there's a walker in a picture, an older picture. But you saw there's no walker in that living room at all. Emotional abuse. You heard the testimony. He yelled at her, called her out of her name. You heard how he talked to her. In that video, when she was trying to do her bills, he was yelling, he was aggravated with her. And that's what he video recorded. But both Catherine and Jacqueline told you how he spoke to his mother. So much so it raised an alarm for Jacqueline to call ABS. Manipulation of family. He misled his family about the extent and nature of her condition. He told no one about the extent of her conditions. He excluded or denied access to family. He put the dog in that house so nobody would come over. Posted down, she's standing outside now, who used to come over and take her out. Cameron said that dog came into my face and I said, I can't do it. But I used to ask my dad about my mom, he used to tell me she was okay, so I believed it. Isolation, he controlled what she did. He kept her unreasonably confined in the home. She did not have access. Y'all don't see a phone in there anywhere. There ain't no cell phone on the floor. There's no house phone. And I think it was testimony from Cameron, but check your notes, that she used to call her on a cell phone, but couldn't call her anymore. Financial exploitation, we just talked about that. And then she told you she had 9 signs of neglect that she noted. Presence of risk factors for neglect. Cognitive impairment that made her physically and cognitively dependent on the defendant was one of the risk factors she noted in this case. Failure to seek medical care. Last seen by the doctor in July 2014, was supposed to go back in September, never went. He had never renewed her prescriptions. He was told that she could not be left alone, and he left her alone. Did not seek any care for her, even after she was no longer walking, and in that weekend leading up to her death. Mother told her her butt was hurting, he did not. There was delay in seeking care. We already talked about this. He had been sitting on her couch, she had been sitting on the couch, unable to move, and sitting in feces and urine prior to that Saturday before her death. She laid on the floor for 3 days, and although she was eating, yelled, oh Jesus, once he pulled her off the couch, never called 911. Failure to perform adequate caregiving. Again, told in 2013 she could not stay alone. He did nothing to perform any of the caregiving as told to him. Knowledge of dog biting, he did not bathe her for 2 months. You saw those pressure wounds. Bed sores, ulcers, advanced stages, poor hygiene. Her hair was matted. You saw how she kept her hair before. It was nice, out, long, beautiful. Her hair was matted up. She had the chin hairs coming, and we found the mags inside of her. Wounds, poor nutrition. You heard her talk about that. Again, isolation. He left her home without the ability to get out. And there were 2 prior APS reports. Teresa Moman, we wish we could have brought her here to talk about what she did, but she's deceased. So when the defense counsel says, well, the state didn't bring anybody, We know that there was a report, we know that there was an investigation, but unfortunately, Ms. Teresa cannot be here today. So we don't know if it's substantiated or not, because she's not here. So could it have been substantiated? We don't know. And it's not like we're trying to hide it, we just can't bring it before them. We don't know. It could have been either way. And the defendant would have provided some medical care. Remember, that's the last thing I asked Dr. Homey. Had he provided some medical care? Could that have prolonged her life? Her answer, yes. Nursing care, emergency care, anything like that, her life could have been prolonged. So again, guilty. So this lays the foundation for felony murder. When a homicide and felony murder, which is count 2 now, moving up, is when a homicide is committed during the commission of a felony. There must be some connection between the homicide and the felony being committed, and there's no malice is not required. So there doesn't have to be an intent to kill. So you must define that the defendant committed the offense of neglect of an elder person, which we submit that he did, and that victim died during the commission of that neglect. And it does not matter whether her death was intended or not. For felony murder, there must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part. That's important. A substantial and necessary part in causing the death, regardless of when the death ultimately occurred. So what do we have? Dr. Henninger, the disease in her body was caused by neglect and a lack of care. His failure to give her care played a substantial role in her getting the ulcers. Those ulcers led to, what do you say, sometimes a sepsis, probable sepsis, which led to, it could lead to some of the other complications. You had to look at it all together. Remember, they were trying to parse out, well, she could have died from this by itself. And she could have died by this. And what Dr. Hendrick kept saying is, no, you can't take one and the other because these ulcers could have caused the sepsis, which could have caused the hypertension. So you have to all look at it together. And he also said, had she received some care, her life could have been prolonged. His neglect was a substantial portion as to why she died. The autopsy report. He did call it undetermined, but if it was him, he said it would have been a homicide. And what he said was a lot of conversation, and he said it was only been like one person who kind of navigated that undetermined discussion. But it was up to him, it would have been a homicide. But the law doesn't say you base your verdict on the ME's definition. Remember, the ME said we just kind of categorize things for us, but that doesn't mean because it's undetermined, you don't find him guilty. Find him guilty. It's undetermined because there's several causes together. But that doesn't mean because he didn't define it as a homicide, that it's not a murder. That's just how they define and classify their cases. And you've seen this, y'all. This is neglect. It's hard to look at, but I gotta show you. He wanted to tell you yesterday that he saw none of this on her. All them days he been walking, he saw none of it. It's a lie. This is how he left his mama. He saw none. When he pulled off the couch, he definitely saw this one because he pulled off the couch. And as you see, the worst one, where you can see her bones, you see where was she laying down? Her whole skin is missing. And he want to tell you he didn't see that? So he just had that, and he's the one who put the cover over. She didn't put it on herself. But he ain't see that. He lying. Guilty. And the last count of the indictment is murder. When a person unlawfully and with malice aforethought causes the death of a human being, malice may be expressed, which is like the deliberate intention to kill, But what this case is implied, no considerable provocation and all the circumstances show an abandoned and malignant heart. That's why he wanted to tell you earlier that I didn't want to abandon my mother. Yes, you did. That is an abandoned and malignant heart to leave your mama like that. It is abandoned and malignant to see your mama foot swollen up, and as opposed to you Googling, how can I help my mom, you're Googling, what can I do about her death? That is abandoned. You were already 4 days before you called 911 thinking about how can I get her money? That is abandoned. So you're not Googling, I pulled my mama off the couch, can I get her some help? You're not Googling, my mom has a whole hole in her body and I see a bone. Should I take her to the doctor? And then you call 911 and say, don't rush. It ain't an emergency. She's supposed to die. That's for people who like in hospice care, where you in a comfortable bed and it happens. Not this. It's abandoned and malignant. Legal malice is no ill will or hatred, but it's the unlawful intention to kill without justification, excuse, or mitigation. If the killing is done with malice, no matter how short a time the malicious intent existed, such killing constitutes murder. So it doesn't have to be this long premeditation. In that moment when he decides, it's done, I'm not helping her. That's what your intent. Because you thought it was gonna be easy for you to say, I mean, I tried to take care of her. You know, I didn't pull a trigger, I ain't stab her. But your failure to act killed her, and you intentionally failed to act. Because you didn't want the burden anymore. You know, TV shows have motive, we don't have to prove motive. But here, there's motive. He wanted her money. And he didn't want the burden to take care of her. We talked about this. Intentionally not taking your mother to the doctor in years. Failing to get assistance from others willing to help. Failing to get his mother medical care in the months and days leading up to her death.
And all that,
Were the cushions on the sofa
I took them off.
before she got
Well,
stuck?
now, she was in between, there wasn't no cushion where she was. The cushion was like that. She was in between that. I got pictures, she was in between.
Okay, all right. And so to get her out,
Flip the sofa over to get out. I couldn't even get out. So I said, I thought I was going to flip the sofa over to get
I
out.
saw it up against the wall, the way that it was.
The only way I could get
We heard about this. So that's when he's talking about him pulling her off the couch. Googling her bank account. Failed to tell anyone on Super Bowl Sunday about his condition. He closed that wooden door. Knowledge of dog biting. The 911 call. I think my time is getting up. He didn't have any sense of urgency. I'll play a little bit of clip if you want to hear it. You heard it.
Hello? 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 Hello?
Atlanta 911,
Hello?
number 2662, what's the address of emergency?
Yes, this is a non-emergency. My mother is deceased, and it was expected.
Your mother is what, sir?
She passed away.
Okay, so you need the
She died.
police to location, what is that I can help you with?
That's what, coroner, the police coroner? I'm not sure.
I'm not
Who to
understanding you.
call.
He don't sound like I don't know, bring somebody over here. She did, I don't know, bring somebody. They even asked him about the defibrillator. He's like, I ain't got that here. Someone who's expected to die and you wouldn't have these things. He kept saying, but I gave up my life.
I had to give my life up to come there.
I had to give up my life to come there.
See, mom, that by herself, that's why I gave up my life to come back. I made a promise there that I'll feed her and all that, and take care.
And again,
They saying, I just came to help the lady. You know what I mean? Come home and give up my life to come in, put up there and the stuff that I had to witness. I didn't want to see her mama do that.
See, for him, he gave up his life. This him on that Sunday. This him with his mama on the ground. You peace signing, you winking, and your mama laying on the ground. But you're in the grieving process. That's what he told you yesterday. I want to remember, we showed you the second video where he had to turn the music on. It started with the music. This one, his mama on the ground. That is an abandoned and malignant heart. That is the definition. This you. That's you. Piecing up while your mom laying on the ground. You like, I'm about to get paid. She gone. I ain't about to call no doctor. I'm about to get this $100,000 in her savings account.
You got 10 minutes.
Thank you, Your Honor.
You're welcome.
It's abandoned and malignant. He's guilty of malice murder. So at the end, ladies and gentlemen, this is going to be the count you're going to look at. There might be some pieces missing, but ladies and gentlemen, we know what this is. These actions are cruel. These actions, he neglected his mom. He failed to honor his mom. It is horrible. Ladies and gentlemen, we usually do this whole life and death work. And I'm not going to show you the death side because you've seen that. You've seen it. But this beautiful woman, absolutely gorgeous woman, deserved better than what he gave her. She had worked her behind off and decided to retire, to live a good life. Saved up her money so that she can die with at least some dignity when she had to die. She didn't have to die at 83. Had her son given anything, she couldn't be still here today. Some of you all have family members who lived into their hundreds, their 90s with dementia. But because of his ignorance, his actions, she's not here no more. Why? His actions murdered his mother. It ain't involuntary manslaughter. It ain't an accident. It is cold-blooded, heartless, ruthless murder. He's operating on what? What if they think this? What if they think that? You're not gonna tell him anything he don't already know. He know it. That's why he want to come here and lie to you. He know what he did. He know he failed to ask. These are the counts in the indictment. And when the jury verdict comes up, when you get your verdict form in the back, it should look like this. Guilty, count 5 of the indictment, unreasonable confinement. Guilty, exploitation of an elder person. Guilty, neglect of an elder person. Not guilty on involuntary manslaughter, reckless conduct. Guilty on felony murder. Guilty on malice murder, and not guilty on involuntary manslaughter. Remember, you gotta consider that first one first. That should be what your verdict looks like. That's the only verdict that's supposed to speak the truth in this case. Ladies and gentlemen, evil prevails when good men and women do nothing. I am asking you to do something. I'm asking you to give her the honor that she so deserves. I'm asking you to give her the justice that she deserves and find him guilty of every single count in this indictment. Thank you.
Thank you, Ms. Hilton. Ladies and gentlemen, you are going to start your lunch break right now. The only thing that remains before you begin your deliberations is for me to give you the jury charge. It's kind of long, is not nearly as dynamic as Ms. Jenk's performance or Ms. Hilton's performance. So I will not inflict that upon you right now. And unfortunately, you'll be well fed when I do read it. So it's going to be hard to get through it, but you will. And we'll do that once you get back. It is 12:50 on the court clock. Any reason you could not be back by 1:45? Anyone for whom 1:45 is too short a lunch break? Let's be back by 1:45. I will charge you then, and you'll be able to begin your deliberations. During this lunch break, don't start talking about the case. Deliberations start only after you get the law from me, not from the lawyers. And you get all the evidence back there, the verdict form, the indictment, et cetera. So enjoy lunch. We'll start as close to 1:45 as we can, and we'll take it from there. All right. Thank you so much. You all can be seated. I'm going to I think we're on Courts Exhibit 2. I think Courts Exhibit 1 was the email from Mr. Smith, who is probably in Las Vegas now. Courts Exhibit 2 will be the 44 note cards submitted by the jurors, constituting all of their potential questions. Only some were asked. Those are in the record in terms of things I asked on behalf of the jurors of different witnesses, but all 44 cards will be part of the record as Courts Exhibit 2. During the lunch break, I need the two sides to confer about what goes back with the jury and what doesn't, so that when we reconvene at 1:40, we can talk about any disputes if there are disagreements about what doesn't go back. Medical examiner's report does not go back with the jury. Certain things were demonstrative, or they would be continuing witness violations. Most things do go back with the jury, including some things that they can't do anything with unless they ask to watch the video again, as they've been told to do. But please work through that before we reconvene. I don't like it when the jury has to wait for 20 minutes because we're duking it out over which pictures go and which don't. Otherwise, the lunch break is yours to do with as you see fit. Ms. Hilton, anything else from the state? Mr. Korn, anything else from the defense?
No.
All right, to both sides, thank you for your hard work on this case. This was not an easy case, and I don't mean like there were legal complicated issues. You've thrown plenty of those at me, but emotionally, it was a very difficult case, and you have been very civil to each other and professional, and most of all, prepared. And that has made this difficult set of facts flow a little more smoothly for the jury. I need you're welcome to stay in the courtroom, but I'm having a meeting about my next trial calendar, which starts on Monday. Ms. Hilton doesn't have a case on it. I don't think Mr. Korn or Ms. Jenks do either. So you're welcome to stay, but I think other lawyers may come up to the table. You don't even need to take a lot of your stuff away. Just need to give them space so they can do that. And we'll start that meeting, Mr. Hiles and anyone else who is here. I think we said 1 o'clock. Okay, if everyone's here before 1, we'll start a little before 1, but that's about 6 minutes from now. Okay. Thank you.
Call Mr. Brandis
Okay.
because so we're gonna do it, we're gonna call him out here,
Okay.
put it on conference.
That's all right. Let me do a couple things here. All right, Ms. Rivers, are you ready? I think I've turned the audio back on in here. It is 1 minute early, but if he's coming back, I won't get the jury in here before he gets in here, but we can do what we're doing because Mr. Rooks has one of his lawyers here. It is about time to charge the jury. The jury charge both sides have. I've got the hard copy that the jurors will receive. I also provide them a visual of what's being read to them. So I'll just show you. You can see that's the language. It'll bounce along in the screen as I read it to them so that they have a visual in case that's easier for them to follow. Ms. Hilton, is there anything we need to cover before the jury comes in?
Nothing from the state, Your Honor.
Did you and your colleagues meet with the defense about what exhibits go back and what don't?
Yes, Your Honor.
Were there any disagreements from the state's perspective?
Yes, Your Honor.
Okay. Ms. Jenks, did the defense have disagreements as well?
Yes, Judge.
Okay. Many or just a few?
It's a huge one.
Okay.
About 30, and that's why I was like, I think, Corn has been
Well,
in the restroom.
okay. I don't want to rush it, but it's now actually 1:45. Are all the jurors back? Should have 13. Okay.
Yes, Your Honor, you're on.
Thank you. Well, why don't we start by you, Ms. Hilton, or someone from your team letting me know which the exhibits are. I'll make sure to wait for Mr. Korn to hear the defense perspective on it, but let me hear the state perspective.
As to which ones are,
Where there are concerns. My understanding is 99% of the exhibits that are going out, there's full agreement, but there are a handful that someone thinks should go out and the other side doesn't.
yes, Your Honor. State Exhibit 150, which is the PowerPoint presentation for
Leon Packer, financial.
The financials.
Mhm.
164, which is the demonstrative skin graft. 149, which is the power control wheel.
Yep.
And then the medical records, which is 111, 112.
Actually, I did not object to the medical records. I think those are properly admitted.
Okay, so let's put them in the box. So we're down to 3, which is, I think what Ms. Jenks said. 2 demonstrative aids, and then I don't remember if the PowerPoint was introduced as a demonstrative aid or not. Okay. So let me start with Ms. Hilton. You guys can go back to your tables. Ms. Hilton, tell me why those exhibits should, I assume you are an advocate for them going back to the jury.
Yes, Your Honor.
Okay, and there's opposition to that. So I guess why don't I start with Mr. Korn? Why should those 3, if we default to having our jury get as much information as they can from evidence that's been admitted, why should those 3 not go back?
Their continuing testimony exhibits, especially and most inappropriately, the PowerPoint presentation, which by Detective Leon Packer's own admission on the stand was incomplete and inaccurate, did not include much of Mr. Brooks's income. I don't think it's appropriate for the jury to focus at all on something that was not sort of that exhibit. They have Detective Leon Packer's testimony, which did include the evidence of the income that he did not feel necessary to include in the complete PowerPoint presentation.
What about the other two? The wheel of abuse, whatever it's called, and then the 4 stages of decubitus ulcers.
Again, I believe those are continuing testimony. We have more than enough testimony on both of those issues. I don't think the jury is aided any by it, but certainly can be prejudiced by it unduly.
I'm just reviewing something. I hear you. All right. Ms. Hilton or colleague, what's the state's response?
Your Honor, the state would cite to Ruffin v. State, which is 333 Georgia Ave 793, that none of those exhibits are continuing witnesses, Your Honor. That case, along with its probably hold that anatomical charts or drawings used by witnesses during their testimony are not the functional equivalent of a deposition, but rather demonstrative evidence that serve only to illustrate testimony given by the witness.
Did, I think I know the answer, but Dr. Henninger did not mark up the exhibit. It doesn't have his writings on it.
Correct, it did. In fact, in this case, even if it did, you could still go back, but it did not have any writings on that document.
And the same with Dr. Holmeyer. She didn't circle certain parts of the wheel of abuse or wheel of pain.
Correct.
To emphasize. Okay. And then finally, is it your recollection that Detective Leon Packer's testimony is that his PowerPoint was a compilation, perhaps incomplete, but a compilation of data that was already admitted, the financial records?
Yes, Your Honor, and the state will cite specifically to a PowerPoint presentation, Moore v. States, which is 311 Georgia 506, which is actually a May 2021 case, in which the court held that the trial court did not violate the continuing witness rule by sending out with the jury during deliberations a PowerPoint presentation that summarized the admitted, in that case, was cell phone evidence, and that's what we said, the admitted bank records, because the sum of admitted cell phone records be sent out with the jury. Excuse me. A PowerPoint presentation that summarized the admitted cell phone evidence, because the summary of admitted cell phone records could be sent out with the jury during deliberations without violating the continuing witness rule, and contrary to the defendant's suggestion in that case, that the fact that the lead detective prepared the PowerPoint summary has no bearing on whether the continuing witness rule was violated.
Okay. Mr. Korn, anything you want to add to wrap things up as the movement to exclude these 3 items from the jury room?
Just that the witness himself, like Leon Packer, admitted that the PowerPoint was not complete, that it was inaccurate. I don't think it's appropriate to send that back.
Okay. I'm going to let all 3 go back. The continuing witness rule, insofar as it has survived the amendment to the rules of evidence, and I think the case law shows that it has, is designed to prevent someone's continuing testimony. And so what it typically excludes would be a transcript of that person's testimony, or a report that that person prepared in light of pending criminal proceedings or something like that. While the PowerPoint arguably could fall into that second category, it is a compilation. It may be an incomplete one, but I don't think the requirement is that the compilation have everything in it. It is simply a summary of some of the data, and it would be through cross-examination, as occurred in this case, that it's brought to the jury's attention that perhaps Detective Leon Packer's compilation didn't include everything, but that's in evidence that it doesn't include everything. So I will allow 149, 150 and 164 over defense objection to go back with the jury. Was there anything else, Ms. Hilton?
The only other thing, Your Honor, I just think is, state in the defense, want some guidance from the court. State's Exhibit 113A, which is a excerpt of the larger cell phone records with a few pages printed out. There's some content in there that did not come into evidence. And so I think the state, in agreement with the defense, would ask if the questions have jurors questions about dates and time, then we just provide that information to them rather than sending back the excerpt, because there is some information in those excerpts that was not.
So two things. If the defense doesn't object, then we probably can do it. But two, it sounds like that'll be context specific. If 113A, which is in evidence, contains the answer to an inquiry from the jury, can we know when X happened? I'd be inclined to say, let's provide that answer by me writing something on the back of a note card if it's derived from 113A. So I'll give you a conditional yes if Mr. Korn says, we don't object to that concept, but I think we'd need to see what the jury's question is, because if it takes too much divination from looking at 113A to get, well, I know this picture was taken on this day, that sounds like the same day, there may be a disagreement. But if the question is, on what date was the picture of Ms. Rooks stuck in the couch taken, because they don't remember, that is knowable by looking at the evidence, but it may be a piece of evidence that didn't go back with them. And that's where I'd be comfortable, rather than sending 113A back, saying, here's the date.
Agreed.
Okay.
I agree with that.
Okay. So
Rather that than send it back.
So let's test that concept out if those kind of questions come up. All right, anything else from the defense before we bring the jury in for their charge?
No.
Jurors, please.
All right, the jury, come on in.
Thank you. Ladies and gentlemen, welcome back from lunch. It's my turn now. You all can be seated. I am going to share with you the law that you must apply to the evidence as you find it to be in this case. A couple things before we get started. Number one, I'll be reading from this document. Some of it I know, so I may be making eye contact, but the language of the charge is in this document. You will have this with you during your deliberations, so don't try to write it down, which leads to point two. There is some legal mumbo jumbo in here. There are certain legal concepts that higher courts have said, trial judge, here's how you have to define it. So I'm going to at times be using what may seem to you, except for the people who are English teachers, that's kind of funky, stilted language. That's not how I would normally interact with folks. I try to make the jury charge as accessible as possible because it's important. It's the law that you have to apply in this case. But certain things I'm required by law to describe in a certain way. You heard Ms. Hilton talk about abandoned and malignant heart. She didn't make that up. That's actually the law I have to give you as to a little piece of how murder works in the state of Georgia. So I'll be reading this to you. Additional point, some folks like to see what they're hearing. And so on that screen, you will get the jury charge as I read it. There's no bouncing ball, so it's not gonna be quite that easy, but I'll try to move screen by screen with what I'm doing here. You will not get the PowerPoint back there, but you'll get this actual jury charge. I think that's it. So let's get started. We're gonna pause partway through, not for you to take a full break, but just to move around a little bit because you need to absorb all this. All right, let me get to the PowerPoint. Here it is. Okay. Make this small. A grand jury has indicted the defendant in this document, which you will also get during your deliberations, for murder, felony murder, neglect to an elder person, exploitation of an elder person, and unreasonable confinement of an elder person. The defendant has entered a plea of not guilty to these charges. The indictment and the plea of not guilty, which is this set of signatures here on the indictment, form the issue that you must decide. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent until proven guilty. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state bears the burden of proving beyond a reasonable doubt every material allegation in the indictment and every essential element of each crime. And I'll be telling you what those elements are later when I define the crimes. There is no burden of proof upon the defendant, and the burden never shifts to him to introduce evidence or to prove anything. If a defense is raised by the evidence, the state must negate or disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. A doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is not a vague or arbitrary doubt, but is rather a doubt for which a reason can be given, a reason that arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant a grave suspicion of the crimes charged, or that merely raises a speculation or conjecture of the defendant's guilt, is not sufficient to authorize a conviction. It is my responsibility to determine the law that applies to this case and to instruct you on that law. That's what we're doing right now. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence that has been presented. Then you must apply the law that I'm giving you now to the facts you find. You must decide this case based only on the evidence presented during trial. That evidence consists of all the witness testimony and the exhibits that were admitted. Evidence does not include, where'd it go? The indictment, the defendant's plea of not guilty, anything I've said, anything the lawyers have said, to include their opening and closing remarks. And finally, evidence does not include questions that were posed. And that is particularly germane to your questions. You may have asked some questions that weren't ultimately posed to the witness. You should draw no inferences or conclusions from the fact that your question wasn't asked. That just meant that there was a legal reason for that question not to be asked. It's only answers to questions that are evidence. Now, the evidence that you've received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I saw the car run the red light and hit the pedestrian. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. I didn't see the accident, but I heard tires squealing and someone said, oh no, he just hit the pedestrian. That could be circumstantial evidence that the car hit the pedestrian. There's no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence in this case, You may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of witnesses who testified in this case. In deciding this, you may consider all of the evidence, because you've got it now, the witness's manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against the party. The credibility of a witness may be attacked by disproving facts to which the witness testified. You may also consider, where applicable, other evidence offered to attack the credibility of a witness, including evidence of a witness's bias for or against a party. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony before you to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and his trial testimony. You've heard from several witnesses who have been designated as experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person, people like you and me. These witnesses are permitted to give their opinions based upon that training and experience. However, testimony of an expert, like that of all witnesses, is to be given only the weight and credit you think it is entitled to receive. Ladies and gentlemen, the testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. A statement that the defendant made to law enforcement has been offered in this case for your consideration. Before you may consider it as evidence, you must determine whether the statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights, sort of repeats what I already said, and whether he clearly understood and knowingly gave up or waived those rights. The constitutional rights that the police must explain and that the defendant must understand and voluntarily give up or waive before any custodial statement is taken are as follows. Number one, that the defendant has a right to remain silent. Number two, that if the defendant chooses not to remain silent, anything he says could be used as evidence against him in court. Oops. Number three, the defendant has a right to consult a lawyer before any questioning and to have that lawyer present with him at all times during any questions. And number four, if the defendant cannot afford a lawyer will be provided for him at no cost to be present with him during any questioning. The state must establish that all these warnings of all these rights were given, that they were understood, and that they were knowingly waived or given up by the defendant. To be voluntary, a statement from a defendant must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestion or promise of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not given under compulsion or any necessity imposed by others. The state must establish that the statement here was voluntarily made. If you do not find that the statement was voluntary, you may not consider it for any purpose. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. A defendant's out-of-court statement that is not supported by other evidence is not sufficient by itself to justify a conviction, even if you believe it. However, proof by other evidence that the crime or crimes alleged have been committed may constitute supporting evidence of a defendant's statement. The law does not fix the amount of supporting evidence necessary. You must determine whether other evidence sufficiently supports a defendant's statement so as to justify finding the guilt of the defendant beyond a reasonable doubt. Talk a little bit about limited use evidence. Sometimes evidence is admitted for a limited purpose. Such evidence may be considered solely for the issue or purpose for which the evidence has been admitted, and not for any other purpose. Evidence, if any, of prior difficulties between the defendant and his mother has been admitted only for the purposes of illustrating, if it does, the state of feeling between the defendant and his mother, as well as motive and intent. Whether this evidence illustrates these things is a matter for you to decide, but you are not to consider the evidence for any other purpose. The defendant is charged with 5 crimes in this indictment. A crime occurs when the law is violated by a defendant's intentional action or inaction. Intent is an essential element of every crime and must be proved by the state beyond a reasonable doubt. Criminal intent is not the intent to violate the law, but means simply the intent to commit the prohibited act. Intent may be inferred from the evidence, and it also may be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find such intent or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. Every person is presumed to be of sound mind and discretion, although this presumption may be rebutted. You may infer that the acts of a person of sound mind and discretion are the product of that person's will, and that a person of sound mind and discretion intends the natural and probable consequences of those acts. All right, I'm going to read one more, and then we're going to have that move around break, because then we're going to get into the elements of the crimes that are charged. But first, accident. No person shall be found guilty of any crime committed by accident in which there was neither criminal intention nor reckless conduct. An accident is an event that takes place without one's expectation, intent, or design. If you find that the incident that is the subject of this case occurred as a result of misfortune or accident, and not as a result of criminal intent or reckless conduct, then it would be your duty to acquit the defendant. When the question of accident is raised, the burden is on the state to disprove it beyond a reasonable doubt. All right, before I talk about murder, everyone stand up. We are a little more than halfway through what I need to read to you, but I need you to be alert for the rest of it. All right, Ms. Rivers, you ready? Got your beverage break. Murder. For murder, the state must prove 3 things: that the defendant, number 1, caused the death of another person, 2, did so unlawfully, and 3, did so with malice aforethought. The killing must have been done with malice to be murder. However, malice, as the term is used in defining the elements of murder, is not necessarily ill will or hatred. Rather, it means the unlawful intent to kill without justification. You may find malice when the circumstances show that a defendant acted with the deliberate intention to unlawfully take the life of another. You may also find malice when there does not appear to be significant provocation and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. If malice was in a defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Proof of motive is not essential to the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the time of the homicide. The defendant is also charged with felony murder in this case. For felony murder, the state must prove two things. One, that the defendant caused the death of another person, and two, that he did so by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. And I'll tell you, neglect of an elder person, or neglect to an elder person as it's charged, is a felony. You may find the defendant guilty of felony murder if you believe that he caused the death of his mother by committing the felony of neglect of an elder person, regardless of whether he intended the death to occur. There must be some causal connection, however, between the felony, neglect of an elder person, and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. There are two forms of involuntary manslaughter that you'll be considering here. Neither one is charged in the indictment. They are what's called a lesser included offense. So you need to consider them because they're a subset, if you will, of some of what's charged here. The first form of involuntary manslaughter has reckless conduct as an element. So we'll call it reckless conduct involuntary manslaughter. For this form, the state must prove three things: that the defendant, number one, caused the death of another person; two, without intending to; and three, by committing the crime of reckless conduct. Reckless conduct occurs when a person causes bodily harm to or endangers the bodily safety of another person by consciously disregarding a substantial and unjustifiable risk that his act or omission, inaction, will harm or endanger the other person, and that this disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in that situation. Now, there's a second form of involuntary manslaughter that you need to consider as well. It's what we call lawful act involuntary manslaughter. And for this form of involuntary manslaughter, the state must prove that the defendant, number one, caused the death of another person; two, without intending to do so; three, by committing a lawful act in an unlawful manner that was likely to cause death or serious bodily injury. Count 3 in the indictment charges Mr. Rooks with neglect of or to an elder person. And that is defined as follows: a guardian or other person supervising the welfare of or having immediate charge, control, or custody of an elder person commits the offense of neglect of an elder person when that person willfully deprives an elder person of health care or necessary sustenance to the extent that the health or well-being of the elder person is jeopardized. An elder person means, for the purposes of this law, anyone who is 65 years old or older. The state does not need to prove that the defendant had some legal duty to provide care for his mother for you to consider the crime of neglect of an elderly person. The law applies to a person supervising the welfare of or having immediate charge or custody of an elder person. Count 4 charges exploitation of an elder person. It is unlawful for any person to knowingly and willfully exploit an elder person. Exploit means illegally or improperly using an elder person or that person's resources through undue influence, duress, abuse of access, or other similar means, all for one's own profit or advantage. And count 5 charges unreasonable confinement of an elder person. It is also unlawful for a person to willfully inflict unreasonable confinement upon an elder person. We're going to get into a little perverse grammar here that exists in the state of the law, in the state of Georgia. And equals or. Where in the indictment, and again, you'll have it, you can read it, the state alleges that the defendant committed a crime in more than one way, that he did X and Y in the same count. The state does not need to prove that the defendant committed the crime in each way charged. If you find beyond a reasonable doubt that the defendant committed the alleged crime in at least one of the ways that is alleged in that count, you may convict. Venue. Criminal cases must be tried in the county in which the crimes were committed. The question of venue, which would be here, were the alleged crimes committed in Fulton County, must be proved by the state beyond a reasonable doubt as to each crime charged. Ladies and gentlemen, in the jury room, you will have this verdict form, and you saw a little copy of it on the screen during Ms. Hilton's presentation. You should consider each count individually. The defendant may be found guilty of some, all, or none of the charges. If after considering the evidence together with the charge I'm almost done giving you, you should unanimously find beyond a reasonable doubt that the defendant did commit here in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. In that event, the form of your verdict would be, we the jury find the defendant guilty. And actually, I'm not going to write the word guilty. You see what it says on the screen. You're actually going to check. It says guilty, not guilty, much as you saw on the screen in Ms. Hilton's closing. You will indicate if you reach a unanimous verdict as to, let's say, count 5, and that unanimous verdict is guilty, you will check where it says guilty. If instead you find not guilty, you'll check where it says not guilty. It's pretty obvious what you need to do, but you won't be writing the word guilty next to where it says guilty. You'll check one or the other. I did not tailor this jury charge to this verdict form. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty, your obligation to acquit him. In which event, the form of your verdict would be, we, the jury, find the defendant not guilty. And for that offense, you would check the blank next to the phrase not guilty. Don't write the words not guilty. Check next to the phrase not guilty. Whatever your verdict is for a particular count, it must be unanimous. And your verdict must also be in writing, which is why you have this form, signed by your foreperson, who we'll talk about in a minute, and dated. Before you can consider the crimes of murder, felony murder, neglect of an elder person, or reckless conduct, involuntary manslaughter, you must first consider lawful conduct, involuntary manslaughter. And this is set forth on your verdict form as well. So you have it in your jury charge, but this instruction about where you have to start is on the verdict form. If you find beyond a reasonable doubt that the defendant committed involuntary manslaughter based on lawful conduct, you may find him guilty of that offense, but you may not find him guilty of murder, felony murder, neglect of an elder person, or reckless conduct, involuntary manslaughter. And that is so because you will have found that the defendant lacked the necessary mental states to commit any of those other offenses. Similarly, if you find beyond a reasonable doubt that the defendant committed murder, felony murder, neglect of an elder person, or involuntary manslaughter based on reckless conduct, you may find him guilty of one or more of those offenses, but you may not find him guilty of involuntary manslaughter based on lawful conduct. Ladies and gentlemen, by no ruling or comment that I have made during trial have I intended to express any opinion on the credibility of the witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws that I've given you in this charge. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. It is also your job to report to me if you perceive that a juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are, as I've said before, the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. Now, in a moment, you're going to be back in that jury room. And one of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign this verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind and consult with one another and consider each other's views. Each of you must decide this case for yourself, but only after you've had a full discussion of the case with your fellow jurors and carefully considered the evidence. 2 charges left. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any outside research. You have all the evidence you're going to receive in this case. It would be improper to supplement it with evidence outside the case. To make that easier for you, the deputies are going to collect all your electronic devices. So before you can begin your deliberations, we don't pat you down, but we need to get Apple Watches, iPads, computers, anything where you could look something up or communicate with other people. We'll keep those safely, and I promise you'll get them back when you're done with your deliberations. From here on out, if you need to communicate with me for any reason other than, hey, what time can we leave? It must be in writing. So if you have questions that you hope to have answered, concerns that need addressing, again, other than we're out of water or there's no toilet paper, please write them down. You'll get them to Deputy Gordon or one of his colleagues. He'll get them to me. I'll consult with the lawyers, and I will give you whatever response I'm allowed by the law to give. Every once in a while, you'll have a great question, and what I have to write on the back is you have to rely on your collective recollection. Don't get angry about that, but you may say, hey, could we have a transcript of that witness's testimony? You cannot. I told you at the beginning of the trial why you should take notes. You don't get to replay testimony. You may want to replay a video. If there's evidence that requires coming out here to put it up on a screen, that's okay, but you're not going to get transcripts of anyone's testimony. So I'll try to have my answers be as helpful as possible, consistent with the law. But sometimes those answers are going to seem like I just didn't hear your question. And I did. And I'll say, you got to go back and figure that one out yourself. That is it. In a moment, you all are going to stand up and go back there, relinquish your electronic devices, and begin your deliberations once the evidence, which is in that box, and this charge, the indictment, and the verdict form get there. It's going to be like 2 minutes, and then you can begin. One of you, however, needs to stay out here, and that is Ms. Mitchell. So Ms. Mitchell, if you'll stay put, who's Ms. Mitchell? You're Ms. Mitchell. You can sort of get out of the way while people are leaving, but I need you to stay here because we need to talk to you for a second. Everyone else, go on back and start unholstering your electronic devices. And once you get the evidence, the verdict form, et cetera, you can begin your deliberations. Thank you. You're good right there. That's why we're gonna put you on the witness stand. You all can be seated. Ms. Mitchell, you are our alternate. So it was important that you heard all the evidence. If we lose a juror, we already lost one. We actually had two alternates, and then Mr. Smith wouldn't take his oath. And so he got to watch the trial from out there. But if I have to excuse a juror for any reason, you will join that group. They will restart their deliberations, and you will be a deliberating juror. What that means for today is that you're going to stay here. You do not need to forfeit your electronic devices, but you may not conduct outside research. It's not yet time to say, let me tell you what I've been doing for the last week. You need to stay in that cocoon or that bubble, but you can read, you could do work, you could sleep. We're going to get you set up probably in that backup jury room right there, but your own room. We will not forget about you. If the jury sorts things out today, we'll bring you out. If they don't and they need to come back tomorrow, we'll have a conversation at the end of the day about whether you want to remain on call, but you're close enough that you could get down here if we need you, or if really you need to show up as well, because I don't remember where you live. If you live in Johns Creek or you live in Palmetto, that's a hoof to get down here, and we don't want to wait 2 hours if we need to press you into service. Does that make sense? Okay. So I'm gonna have you go back there. You gather up all your stuff. You've already figured out where you're gonna put Ms. Mitchell?
Yes.
All right, Deputy Gordon will get you where you need to go. All right, thank you. Ms. Hilton, anything from the state?
Nothing from the state.
Mr. Korn?
Yes, Judge, two objections to the charges. One, as previously noted, the conjunctive and disjunctive charge, I would object to that and renew my objection this time. And two, the duty of care charge, I have objected to that and would renew my objection this time.
Noted. They are renewed. Nothing was waived. So when Deputy Gordon comes back out, I will hand him the jury charge, the indictment, and the verdict form. And it sounds like if he takes that box out, although I'll note the PowerPoint's not in there, so you may want to make sure that the items we discussed, 149, 150, and 164 are in the box, because they don't look like they're in the box right now. And then I need one phone number for each side that I can call if we need folks back in here. So what's the phone number from the state that I can call?
Area code 732,
What? Where's that?
New Jersey. Not where I'm from, but where my parents went to.
Okay.
For Philadelphia.
All right.
39 9769.
All right. You could write it down next time. All right. I think I got that. And what's the phone number I call for the defense?
678-777-6033.
It's almost like the side of a bus number if you had a few more sevens in there. All right. Great. Those will be the numbers we call if folks aren't in here when I pop back out, should the jurors have questions, concerns, whatever it is. Otherwise, you all can be at rest. Just don't be too far away, because we'll get going once I get one lawyer from each side in here and Mr. Rooks in here. Wow, that was a long way around. So Deputy Gordon, don't go anywhere. You'll take those three things, that banker's box, even says banker's box on it. That goes back with the jury. So once they got that, they can get going. Thank you.
Yeah. Okay. So, just in case it. Right. Oh, you gonna be all right? Oh, you got it. Just really, I'm not to leave and then. We're just gonna. Last one is probation revocation.
It's not about me.
Jeez.
It's 4 years now. But in my life, no. Yeah. Go ahead. Also, which. Not having.
Where is she in set?
Well, she just needs me to grab cookies from her. I know where she is. Sorry,
I'm here,
come
I
back.
just do pop-ups, really, when I'm at the courthouse, I go see everybody.
I think she was just like, I will, I think she was just, I don't know what she's doing. I'll let you know if I come.
Okay.
Jackie's looking for you. No, you don't have to hang out, you can go out there if you want. Just on the hallway or on the seating up there. Or you can stay here, doesn't matter. It's true.
Right, popcorn, I'm out.
Miss Jackie, take care. unaware that this is true. Hi. Did you say hi to Marilyn?
Yeah.
She's kind of my hero.
She's kind of my hair too.
When they call, I'll be back. Just realized I was.
Yeah.
What's that? Yeah, don't want to be that guy. Audio or something? They can hear me saying, I don't want to be on camera? Okay. That's not a secret.
No.
Or is that more detailed than you wanted?
All right, I'll be back when we get the call, or a call.
Yeah.
Yeah. Never mind there.
Just checking on some here, right? Do you feel okay to go in home? Where tomorrow? Right. Okay. All right, we'll just, we'll figure it out whenever. All right. Oh, yeah, we got one, Melody. What's wrong? Gotta wait for the rules.
Do we know where Mr. Korn is? Because you didn't have me call him. You're calling Mr. Korn? Intern?
I called Rachel.
Okay, that's fine. Either one.
Go ahead. Hey.
Hey, you need to come back to court.
You're at the same time.
You called him too?
I called.
Okay.
You want to say here on the end?
Question?
Yep.
And also, the players, what would, you know, squashness.
Ms. Rivers, you ready? Okay, we are back on the record in State versus Rooks. It is a little after 4:00, 4:15, and the jury submitted the following question. What does an abandoned and malignant heart mean by definition of the law? What does an abandoned and malignant heart, and then the word me, as in not you, but me, by definition of the law? I am taking that to mean, what is the legal definition of an abandoned and malignant heart? I will mark that as deliberation question number 1. And my thought is that the answer is the words have the meaning that you give them, or something to that effect. There is not a pattern charge that defines abandoned and malignant heart. It's a phrase that, frankly, I tried to get removed from the pattern charge. I'm on the group that rewrote the pattern charge for murder, and I was sort of like Dr. Henninger in the minority in coming up with the change there. Because of questions like this, what the heck is, it sounds like what you remove from someone who's died from a terrible cancer. But I don't get to write that either. So let me start with the state. Language to the effect of what I shared works for the state?
Yes, Your Honor.
Mr. Korn?
I wish there was a definition too, I'm not aware.
Okay. So I wrote on the back, the words have the meaning your knowledge and experience give them. Any objection to that?
No, for the state, Your Honor.
Mr. Korn? All right, I initialed it, dated it, and I'll have Deputy Gordon return it to our friends in the jury. Thank you. Ms. Rivers? This is court's exhibit. I think it's 2.
Just Jeff, feeling on how long you let deliberate today.
We're not on the record. You don't need to take that down. Good question. I talked with Deputy Gordon about that, who's sort of the MC now, not so much me. I'm going to have him, Deputy Gordon, check with the jury in a little less than a half hour, a little before 5, saying, how's it going? You can only go till about 6 today, but you can come back tomorrow at a time of your choosing. He'll let me know, and then we'll convene as we see fit. But the shuttles stop running at 7. I don't want to say you have to stop at a particular time. I want them to know it's a little elastic, but I like having a soft ceiling of 6. If at 5:40 they were to say, we only need a half hour more, they'll get that half hour. And then we'll see what happens. But sometimes that half hour more is suddenly another hour. Then I'll say, look, you just need to go home and we'll come back tomorrow. But I'll have Deputy Gordon do that soft check in 20, 25 minutes. That answer your question?
Yes.
All right. Ms. Hilton, any questions?
No, I'm saying,
Okay. Thanks all.
Yeah, I know, it's problematic.
That's fact.
It's antiquated language. That maybe she's.
It does. It's really
Here, I feel like when I hear this word.
Macbeth.
I want to dress.
Forsooth, this abandoned and malignant heart.
I want to put TH on the end of every word that I say it.
They slip in the hand and contaminate.
Maybe we can make some strides in changing that.
I'm gonna get it.
But is it on the screen right?
This is what's being shown.
I think right.
I think it's where it says live.
It's probably said.
Yeah, you're definitely on there.
Okay. Yeah, I mean, just.
They do, so we got comments on that?
I would think it needs more of this.
Yeah.
Yeah, but it's whatever they think.
I have to take it out.
Yeah, it should not read those.
Cause then we. Yeah. I
Says, I don't think he hated anyone.
Well, that's true, he didn't, he couldn't.
Blake could be cancer.
Well, no. Not by, it's not, there's multiple definitions. Yes, it means that.
Yeah.
I'm gonna sit up there where I have no cameras on. You're not on,
no,
it's just me and her, and her.
Yeah.
I could. But, going wrong.
Yeah. So that's it. That's it. There's some general says general, so. And then, and her next over to math, so, but whatever. When they came out. And so we merge into the math, and then you just go and catch up. I don't know, you walking?
Yeah, it's one from headquarters, but yeah, I would have written a little earlier. This is the, y'all, this is mine. I guess, you were mine, you didn't order
I
mine?
did.
Yeah, they probably got his names on.
Okay. Thank you so much. I gotta do that.
Right.
Okay.
Yeah, it's nasty outside.
Share box.
That's not today, that's, yeah.
Actually, the sites of it. And that's.
I keep giving you some engineers.
Oh. I'm so sick. I'm like, yes. You can't see you.
That's not.
Did you,
General chains, spicy shrooms. That's what I keep sharing. It's fun. But yeah, I do like that. And then of the
lights on. Definitely. That you're ready to question. It may be. Yeah, yeah.
I'm sitting here. It. I accessed it. And I didn't know it was the first one.
If it's white, with a blue light. Stuck in the
Reason. On the right side of.
right side of the light. Told you not to do that. Sorry about us.
Absolutely. That's it, yeah.
This is one copies of the charge.
Sure, what did you?
They want a copy of your charges, probably won't have to take already.
It's good.
Yes. This is- oh my goodness. It does, it goes down low, you know? You're not good. I am done.
Oh, okay, you- Yeah, but like, it is so hot.
You can drink it, but it's cold.
No, that,
Yeah. Is there a thing that? I don't have the box. Yeah, the box. My kids in the. Yes, probably good. She does. Send her email us and see. Cool. I can do anything for this. Something. Say when ready. Yeah, when I need to. Don't be like me. We need to put it right across. So. She has. She's driving, so I think that's it.
Not this one.
The box, the box.
The plug part.
Yeah, I mean.
You know what I do have?
I know that you're gonna have her.
You know what I do?
Oh, I got it. That's awesome.
I have a plug. Always have.
I got it. I got it.
You turn
Yeah, sure.
Hi. Do we see Deputy Gordon recently? I
Oh, he went that way.
can't go back there.
Is he going again?
No, I mean, again, I just hadn't heard the update, so I was wondering,
He's checking.
you checking with him now? Okay, he'll come find me.
Oh, yeah, but I don't think I'm gonna do that, 'cause as long as you're getting encouraged, you don't need to do all this. Install this stuff. Thanks, yeah. So,
Yeah, right.
it's-
I had that for a long time.
No, they're probably right. It's stepping up. I have Google first and other platforms.
Right,
I don't want to change. I'm not counting Google.
yeah, no, I mean, it took me a long time. Now I got it. Customers.
I went this way because initially iPhones were only on AT&T. And we had AT&T. Well, actually, the predecessor of AT&T down south. But I hold a grudge, so.
They'll send us a flyer, right?
Yeah, and here, it was here too, they uploaded the. Which at the time was a big deal.
Right.
That's the phone number.
Oh, that's all.
Give me that phone number.
Right.
That's me. Starting to deep hole. We followed that for years. Wanted me to keep paying for the other one, just paying for that.
Right. That's crazy.
Mhm. In Redmond.
Yeah, sure.
So I,
We're ready. All right, I appreciate you guys taking around.
Readings.
I'll shoot that right. The lights on.
Ms. Rivers, are you ready? Okay, let's go back on the record in State versus Rooks. Deputy Gordon tells me that the jury tells him that they've reached a verdict. So when everyone's in position, we can bring folks in. Ms. Hilton, anything you need to talk about before you're in the middle, before the jury comes in? Okay, Mr. Korn, anything?
No, you're.
Okay. When they're ready, please bring them in. And I guess let's leave the alternate where she is right now. So she should stay where she is. Thanks.
All right, you good?
You all can be seated. Mr. James, you'd stand, please. You're the foreperson?
Yes, sir.
Great. It's my understanding that you and your 11 colleagues have reached a verdict. Is that correct?
That is correct.
Was it a unanimous verdict?
It was.
And have you completed, I didn't mean to interrupt you. It was?
Yes, sir.
Okay. And have you filled out the verdict form, signed and dated it?
Yes, sir.
All right, if you'd hand it to Deputy Gordon so I can see it, please. All right. Thank you, Deputy. Mr. James, I'm going to ask you to publish the verdict now, which basically means reading it into the record. You don't have to read everything in the boxes, just what the jury's verdict was as to each of the entries in the verdict form, please.
Okay. So we're going to start where it says lesser included.
Correct.
Lesser included involuntary manslaughter, lawful act, not guilty. Count 1, murder, guilty. Count 2, felony murder, guilty. Lesser included involuntary manslaughter, reckless conduct, not guilty. Count 3, neglect of an elder person, guilty. Count 4, exploitation of an elder person, guilty. Count 5, unreasonable confinement of an elder person, guilty.
Thank you, Mr. James. Deputy Gordon, if you would share the verdict with Ms. Hilton and then with Mr. Korn. Ms. Hilton, any objection to the form of the verdict?
Not from the state, Your Honor.
Mr. Korn, any objection to the form of the verdict?
No, Your Honor.
Ms. Hilton, anything else from the state before I release this jury from its service?
That's from the state, Your Honor.
Mr. Korn,
Permission to call, would you please hold the jury?
I will. Ladies and gentlemen, I am going to ask each of the 12 of you the same 3 questions. When I call your name, if you would stand and answer my questions audibly so a court reporter can take it down. We'll start with juror 1, Ms. Guthrie. Ms. Guthrie, was the verdict that Mr. James read into the record your verdict in the jury room? And did you freely and voluntarily enter into it? Is it still your verdict? Thank you. Ms. Patillo, was the verdict read here in court your verdict in the jury room?
Yes, sir.
Did you freely and voluntarily enter into it?
Yes, sir.
Does it remain your verdict?
Yes, sir.
Thank you. Ms. Johnston,
Which one?
Evelyn Johnston, T-O-N. Was the verdict read in court your verdict in the jury room?
It was.
Is that something you freely and voluntarily joined in?
Yes.
Does it remain your verdict?
Yes.
Thank you. Ms. Khan,
Yes, sir.
was the verdict read here in court your verdict in the jury room?
Yes, sir.
Did you freely and voluntarily enter into it? Is it still your verdict? Thank you. Mr. Smith. Oh, forgot. He can't hear us right now. Ms. Moore, was the verdict that was read here in court your verdict in the jury room?
Yes, sir.
Did you freely and voluntarily enter into that verdict?
Yes, sir.
Does it remain your verdict?
Yes, sir.
Thank you. Ms. Patterson, was the verdict read here in court your verdict in the jury room?
Yes, sir.
And is that something you freely and voluntarily entered into?
Yes, sir.
Is it still your verdict?
Yes, sir.
Thank you. The other Ms. Johnston, was the verdict read here in court your verdict in the jury room? Did you freely and voluntarily enter into it?
Yes, sir.
Is it still your verdict?
Yes, sir.
Thank you. Mr. Wojcik? Was the verdict read here in court your verdict? Did you freely and voluntarily enter into it? Is it still your verdict? Thank you. Ms. Terry? Was the verdict read in court your verdict in the jury room? Did you freely and voluntarily join that? Is it still your verdict? Thank you. Mr. James? Was the verdict that you read in court your verdict back in the jury room?
Yes, sir.
Did you freely and voluntarily enter into that verdict?
Yes, sir.
Does it remain your verdict?
Yes, sir.
Thank you. Ms. Libby? The verdict read here in court, was that your verdict in the jury room? Did you freely and voluntarily join it? Is it still your verdict? Thank you. And Ms. Barnes? Was the verdict read here in court your verdict in the jury room?
Yes, sir.
Did you freely and voluntarily enter into that verdict?
Yes, sir.
Ma'am, is it still your verdict?
Yes.
Thank you. That completes the polling of the jury. Ladies and gentlemen, you've completed your service in this case. On behalf of the state, as well as on behalf of Mr. Rooks and his lawyers and the people of Fulton County, I want to thank you. You had to spend a lot of time hearing about a very, very difficult case. It's a case that's been around for too long, and it could not be resolved until a jury heard the evidence and decided the case after hearing the evidence and hearing the law. So thank you on behalf of everyone. You are going to go back to the jury room in a moment. I'm going to come back there and share a few more words with you. You'll get your electronics back. You'll be reunited with your alternate. I've got a letter for anyone and everyone who might need it to prove where they've been or anything like that for home or work. But again, thank you on behalf of everyone for your service. You can go with Deputy Gordon. Ms. Nelson? I give you this. Thanks. Can you get the alternate? Thanks. Is that what you were going to ask me about? No. Okay. All right. You all can be seated. Ms. Hilton, what is the state's preference about sentencing? Is that something you want to do now, or should we set a date in the not very distant future to handle sentencing in Mr. Rooks's case? Excuse me. Okay. Mr. Korn, do you have a preference one way or the other? Okay. Mr. Rooks, you're going to go back into custody for a minute. I need to release the jurors. Some may want to stay for sentencing. That's their right if they want to do that, but I want to let them go. And then I'll come out here and we'll take care of sentencing. So that'll give everyone a few minutes just to get their thoughts together about sentencing.
Thank you, Madam. And I know some of the judges are over, if there are some who are willing to stay, that they stay in the jury room or.
So I'm going to give them the option of waiting there or coming out to the jury box to be here for sentencing. Okay. Get the alternate.
Government notice. Gonna call
That's one.
the one here. I really don't. Yeah.
That's interesting. What's the written address? This is the table. Yeah, this. No, I keep it. This just happens to be. Right. Yeah.
We can get Mr. Rooks out, please. All right, Ms. Rivers, you ready?
Yeah, ready.
We're back on the record in State versus Rooks. The jury has delivered a verdict of guilty on all 5 counts in the indictment, not guilty on the 2 lesser included of involuntary manslaughter. Ms. Hilton, I'm ready for your presentation and recommendation, and then I'll hear from Ms. Jenks or Mr. Korn, and then ultimately from Mr. Rooks if there's anything he wants to say.
Thank you. Your Honor, I've been a prosecutor this year going on 12 years. And I believe this by far is one of the most egregious cases that I've handled. The jury came back with a verdict that speaks the truth. That Mr. Rooks, who should have been taking care of his mother, who was 83 years old, who should have been providing for her, making sure that her last years of life was comfortable, that she was still living a good life. He intentionally failed to do none of it. He spoke so many times in his interview to Detective Leon Parker, into speaking with friends, that he had to give up his life for her. As if she hadn't had to give up her life for him. Raising him at least until he was 18 and still taking care of him, even in her elder age. And it is egregious, Your Honor. It is horrific and it is heartbreaking. Your Honor, we do have Cameron Rooks, her grandson, here in court today. And he has a statement that he's going to ask our victim advocate to speak because he is not able to speak it. And so I'm going to ask Ms. Bradley to come forward and read his statement. And then after that statement, Your Honor, I will come back before you and ask for the sentence for the state's recommendation.
All right.
This is a statement provided by Cameron Rooks. For the past 5.5 years, I've waited for my grandma to receive justice. Ever since I can remember, you were always mean and outright hostile to her. You should have been kind, patient, loving, and understanding, especially in her old age. What you allowed to happen to grandma under your watch is shocking and horrific. You should be ashamed of yourself. How dare you ruin our family name? I'll never understand why you hated me, Grandma Rooks, Granddaddy Rooks, and Uncle Addison so much. When you were around us, you always did everything you could to make our lives miserable, difficult, and complicated. While incarcerated, I truly hope that you reflect on how you mistreated us and get to the root of your own trauma so you can become a better person. Your lack of love and compassion for me caused me to suffer from deep depression and anxiety for years. You deserve to spend the rest of your life in prison without parole since you took grandma's life. Although what you did to my precious grandma is unforgivable, I want you to know that only by God's grace do I forgive you so that I can release you from my life and move on. I'm beyond grateful to finally close this nightmarish chapter of my life with you. Goodbye, Dad.
Thank you.
Your Honor, I think that Cameron says it best. This is a case that he should not see or be able to see outside of a prison cell. So with that, Your Honor, the state's recommendation is as follows. As to count 1, murder, life without the possibility of parole. Count 2, Your Honor, would vacate by operation of law. Your Honor, the state believes that count 3 would not merge into count 1, as it does have an additional element in the charge, which is that neglect, you have to have immediate charge and control of an elder person, which will be an additional element that is not contained within the murder count. So we would ask for 20 years to serve consecutive to count 1. For exploitation of an elder, we would ask for 20 years to serve consecutive to count 3. And for unreasonable confinement of an elder, 20 years consecutive to count 5. So the state's recommendation is life without the possibility of parole plus 60 years, Your Honor.
All right. Thank you, Ms. Hilton. Mr. Korn?
Your Honor, this case has been as difficult for me as it has been for everyone else, as I'm sure you're aware. Phileas Rooks is 63 years old. I'm sorry Mr. Cameron Rooks had to say the things that he had to say about his father. That is disturbing on a variety of levels for me, when it seems to me the evidence was he gave him his musical career. They were on good terms at least up until the very end. And since this happened, not so much. And of course, Mr. Rooks hasn't spoken to his son since this happened. Mr. Rooks has no record. He's never been in any trouble before. He sits here, he's made one awful mistake. On the day that his mother came out of that couch, he should have called 911. I do not believe we would be here now if he had done so then. Did he treat her well before that? Remember, he only lived there for 2 months before that. I believe that life without parole is an extraordinarily high sentence for somebody with no record. I would ask the court to sentence him to no more than life in prison on count 1 and concurrent sentences on counts 4 and 5. I do believe count 3 merges because it would merge into count 2 automatically, and count 2 essentially is vacated, goes into count 1. So I do believe the count 3 does merge. So I would ask for that one to merge and count 3 or 4 and 5 to be concurrent time.
Okay, thank you, Mr. Korn. Mr. Korn, thank you for all your work on this case. You've been with it for many years, and one reason why we were able to bring it to trial. Mr. Rooks, this is your sentencing, not anyone else's. You have a right to allocute, say something. You don't have to say anything at all, just like when you decided to testify. If there's anything you want to share with me, and the conversation is between the two of us, it's not with anyone else in the courtroom, you are free to say something now, but you don't need to say anything at all. You can rely on what your attorney said.
I'm at loss for words, to be honest with you. I'm a little disappointed in the judicial system. We have the miscarriage of justice. I did not extort my mom. I don't know where this false imprisonment or unreasonable time come from. Extortion, I don't know, but Cameron, I didn't know.
So face this way. If you turn around again, they're going to take you out of the courtroom. Okay?
I didn't know he felt that way.
What they told me instead of sitting me down.
But I still love him. Always did.
Okay. Mr. Rooks, somehow you still don't get it. The fact that it surprises you that your son had the feelings or lack of feelings for you that we just heard about. The fact that you described yourself as someone who loved his mother. It was pretty clear to everyone who watched the evidence in this case, except maybe you, that your actions aren't reflective of the words you just shared with me. Your case is not just one awful mistake. It was weeks, it was months of neglect. Your mother to you was a nuisance. She was a bother. Eventually she became a smell and a stain in your house that you walked by, that you didn't care for, that you didn't once pick up the phone and call 911. If it was too much for you to handle emotionally or physically or financially, 911, 911. And you never did that. Your son is right. You should be ashamed of how this played out. You'll have some years to work through what you call a miscarriage of justice. You misinterpreted what was in your mother's eyes when you looked at her before she passed. You shared with the jury that you saw in her eyes that she was ready to go. She was looking at you asking why. What did she do to deserve the way you treated her in her final months, where she lay in her own excrement? And your solution to that was to toss her some wipes, roll her in orange. Didn't bathe her for her last 2 months. This is fundamentally different from the all too many murders that I see. They're senseless as well, but the suffering is minimal. Someone's shot in the head, they're dead in a moment. Shot in the chest, they bleed out in 30 seconds, 2 minutes. It's suffering, but it's brief. Your mother took weeks to die because of the way you treated her or failed to treat her. Your mother, not a stranger, not an enemy, your mother. Your sentences to count 1 is life without parole. Count 2, vacate. I find that count 3 does merge. I appreciate Ms. Hilton's observation that there may be an element hanging out there. I think that under the rule of lenity and in not wanting to create an additional appellate issue, I am merging count 3 into count 1. Count 1 is premised on the deprivation of medical care and sustenance. I don't think the status element of having charge and control of the elder person would cause count 3 not to merge with count 1. Your sentences to count 4 is 20 years to serve to run consecutive to count 1. And your sentences to count 5 is 20 years to run concurrently with count 4. Your total sentence is life without parole plus 20 years. Mr. Rooks, you have the right to seek post-judgment relief in several forms. I'm going to ask your lawyers, Ms. Jenks and Mr. Korn, to consult with you. My guess is they will file a placeholder motion for new trial. They won't if you tell them not to. They need to within 30 days. Then they will likely roll off your case and you will get another lawyer appointed to represent you who will have a chance to look at the entirety of the case. My performance, any errors I may have made, and any errors your lawyers may have made. And that new attorney will be able to raise all those types of concerns in the motion for new trial. If you choose to file a motion for new trial, as I said, it has to be filed within 30 days, just the placeholder one. You also have the right to a direct appeal to the Supreme Court of Georgia. You can do both. If you do both, motion for new trial comes first. If I deny it, you've got that right to appeal to the Supreme Court to challenge your conviction and your sentence. And you have the right to have counsel represent you for both the motion for new trial and the appeal to the Supreme Court of Georgia. If your lawyers do not file either a motion for new trial or a notice of appeal within 30 days, you waive those rights. And your remaining appellate approach would be to file a habeas corpus challenge, which is a civil lawsuit. You'd have 4 years from your final disposition, the sentence that I'll sign today or tomorrow, or at the conclusion of all your direct appeal rights. So if you tell your lawyers, don't file a motion for new trial, don't appeal, you still have 4 years on your own. You'd have to hire your own attorney if you want one to file a habeas. But if you ask your lawyers to file that notice of appeal or that motion for new trial, then that 4-year clock does not start until you've exhausted all your direct appeals. If you have any questions about your appellate rights, the 2 lawyers flanking you will be able to answer them. Ms. Hilton, is there anything else you think I need to cover or you want to share before we adjourn? Mr. Korn?
No, Your Honor.
All right, I appreciate everyone's time and attention. Mr. Rooks, you're going with the deputies. Counsel, you are free to go.
I've got the.
Yeah.